Yeah, no, it was just electric officership.
Okay, 7 o'clock. Chris, are we ready to call this meeting to order?
Yes, sir.
Okay. My name's Jeff Poofall. I'm the chairman of the BZA. I apologize. I had to be out of town. I'm in San Antonio at Lackland Air Force Base for my job. I wish I was there in person. I know that this is we've got a lot of neighbors involved here, and this is a pretty important meeting. So again, I apologize. At this point, I'd like to call roll for the meeting. Board Member Vest.
Present.
Board Member Clemmer. Board Member Mullen.
Present.
Board Member Powers.
Present.
And Board Member Poofall, present. Gonna give it over to the chair.
I'm sorry, what's
Just notes. In addition to citizens attending the meeting in person, citizens have several options to view or participate in the Zoom meeting webinar as described below. We do our best to take citizen comments remotely. There are two options for citizens to offer a comment. Join the Rockbridge County Board of Zoning Appeals Zoom webinar. Link is available on the county website to copy into the address line on your browser. To join by telephone, you may dial in on one of the numbers listed on the county website. Webinar ID and password are there for your convenience. If you wish to make a citizen comment as a Zoom meeting participant, you will use the raise your hand feature. You can press the raise hand button on the bottom of your Zoom window or press *9 if you are calling in by telephone. At this time, I'd like to proceed with the meeting with the approval of the December 21, 2022 minutes. Has everybody had an opportunity to review the minutes? If so, all I need is a motion from one of the board members.
Motion to approve the 2022 minutes as written. A second.
All in favor? Aye.
Aye.
Okay. Next, we've got an election of officers. This will require a motion, and this would include voting for chair, vice chair, and secretary. Chris Layden is required to be secretary because he is the zoning administrator. Do we have a motion for the chair?
I'll make a motion if you'll do it for you to be chair, Jeff.
Okay.
Could you put your mic down, please, sir?
Vice chair?
We're making a motion for vice chair.
It
Yeah.
could include one motion for all three would be fine.
Yeah, for all three existing.
That could be in the form of a motion.
My motion would be for all three existing
which is, I should, for the record, it is Mr. Jeff Kufall for the chair, Mr. Greg Mullen III for vice chair, and I serve as secretary.
I'm in favor.
Well, we have a motion on the table. Do we have a second?
I'll second the motion.
All in favor?
Aye.
Aye.
Aye. Okay. Finally, we've got a approval for the BZA 2023 meeting schedule. Chris has done an excellent job at most of the year going by without us meeting. As is, our next meeting is, I don't know if, does everyone have a copy of it in front of them?
Yes, sir. It was included in the package.
Yep.
Okay, great. August 16th, September 20th, October 18th, November 15th, December 20th, and January 17th of 2024. That is what's remaining. Is that still correct, Chris?
That is correct, and it's, of course, on an as-needed basis.
Okay. Thank you. Chris, I'll turn the floor over to you.
With that, we would need a motion and a second to adopt the 2023 schedule.
I'll motion to adopt the 2023 schedule as just described.
I'll second.
Thank you.
We got a motion on the floor and a second.
All in favor?
Aye.
Aye.
Aye. Okay. Chris?
Yes, the fifth agenda item is Scott G and Crystal Geis, 336 Muir Road, excuse me, Lexington, Virginia, 24450, application to appeal the May 12th, 2023 zoning administrator's determination that a grandfathered or non-conforming use at Quail Ridge as an outdoor shooting range does not include holding, hosting special events, weddings, in parentheses, weddings, receptions, and reunion. With that, I'm instructed to read the legal advertisement just for the general public. How we're going to go as the flow of the meeting is staff will read the legal advertisement, turn the floor over to Mr. Kirtner for his presents his appeal, then turns the floor back over to myself to present my response, and then we will hold a public hearing. With that being said, with no further ado, notice is hereby given per section 15.2-2309 and 15.2-2204 of the Code of Virginia and section 808 of the County of Rockbridge Land Development Regulations that public hearings will be held by the Rockbridge County Board of Zoning Appeals on Wednesday, July 19th, 2023 at or after 7 p.m. in the Board of Supervisors meeting room in the County Administration Building, 150 South Main Street, Lexington, Virginia, 24450, to consider the following application at this time. Scott G and Crystal Geis, 336 Muir Road, Lexington, Virginia, 24450, has made an application to appeal the decision of the zoning administrator. On May 12th, 2023, the zoning administrator determined that the grandfathered or non-conforming use at Quail Ridge Sporting Club as an outdoor range does not include hosting special events. This decision is under appeal. The property is identified as tax map number 73-A-17 and consists of 84.21 acres per tax records and is located on the east side of Muir Road, further identified as Route 675, approximately 0.67 miles north of the intersection of Muir Road and Collierstown Road. Collierstown Road is, of course, further identified as 251. The property is located in the Carrs Creek Magisterial District. And Stefan, I apologize. I'm gonna need some assistance on the display setting, I believe.
I can see it just fine.
Okay,
So-
I think I got it.
There you
There's
go.
some-
Now you're
there's some
sharing the right.
updates to Zoom that we're all learning today. If you just like to,
Just use the arrows to go back and forth.
well, no, it's not.
I think if you, to move through slides, you should be able to use your arrow keys, either right or left.
That is not working.
Um,
Yep, it is working now. It's just a little bit slow. Apologize. It just left right. You want to go forward?
Okay, thank you.
Yes, sir.
Well, good evening, Mr. Chair, members of the board. My name is Tim Kurtner. I'm an attorney at Gilmer Sadler in Pulaski, Virginia. And I've come up the road today to represent Scott and Crystal Geis on 3 appeals that are before you. Mr. Geis is seated right here on the front row. Mr. and Ms. Geis have young children, and Ms. Geis is taking care of the young children instead of being here this evening. So we'll ask you to excuse her absence while she tends to those duties. As I mentioned already, I think there are going to be 3 appeals that you'll hear from us on this evening. The first, of course, now relating to the special event use. I have brought with me, not because I don't trust Mr. Sladen, but because I don't trust technology in general, paper copies of everything that I'm going to provide to you. So the PowerPoint presentation that I'm hopefully going to find my way through is in those notebooks.
Paused, it looks like. Thank you, Mr. Bullen. Stefan, apologize. It looks like the recording's paused. Is that something I can take care of on my end?
sorry, I didn't realize I was muted. It is recording, Chris. It's recording on my end. Sorry about that.
That's fine. So as I was saying, maybe that was
Not trusting computers.
exactly. Thank you. Right on cue. Thank you, Mr. Sladen. You're helping me out already, right? So we hope we won't have to rely on the paper copies. But so the paper copies of the presentation are in that notebook, as well as some supporting documents that I'll refer to. Instead of giving you 3 notebooks that, one for each appeal, I put the entire PowerPoint presentation. I'm not going to go over all the PowerPoint slides in each presentation or each appeal. Similarly, the documents, the supporting documents that are included, I'm not going to go over all of those in each appeal. So it's my understanding that we're just agreeing that everything that's in the notebook is going to be in the record for all 3 appeals, and we're not going to labor through trying to bifurcate that. That's just going to slow things down. So that's my understanding of where we are procedurally. So in any event, this first appeal may be the easiest one to deal with. And I'll take less of my time talking, and I hope maybe you'll take that in consideration, because I might need more of that time later on one of the other 2 appeals. So this appeal concerns the question of a special event center. And let me say that it's not our position that Mr. Geis is entitled to use his shooting range as a special event center. In fact, he's not doing that. And what we further acknowledge is that some of the language on his website, on which Mr. Sladen relied, probably could lead to the wrong impression about what's actually going on there and what has been going on and what he intends to go on there. So in order to help alleviate some of that, you do have a notebook, right?
Yeah.
Because that
Not progressing.
is not progressive.
Okay.
I got a blank screen. So anyway, I'm going to keep talking while we're trying to sort that out, because you have it in front of you. So is there something I need to do differently?
I think it might be
Just like
sleeping a
poll?
little bit
Okay.
if you just move that every now and then.
All right. Okay. So the first slide is a revised statement on the Quail Ridge site about what they actually do. And what you're going to see from that revised statement on their website is that they are not hosting any events independently. There are times when folks are in town for a wedding, and the wedding party, maybe the bridesmaids, maybe the groomsmen want to come over to the facility and shoot. Sometimes those folks will choose to have a meal while they're there. And if they want to use some space there and have a caterer bring some food out, that's fine. Same is true with reunions. VMI class year reunions have been using this facility for many years, decades, in fact, if you look at the prior record of the prior proceeding, to do events associated with the reunions. And again, those folks aren't charged any separate fee for the space. They're not charged any separate fee for food or for allowing the food to be brought there. It's just an accommodation to people who are there to shoot. The purpose of the events held there is shooting activities, and the folks who come there, again, they can be accommodated in their desire to take a meal there, to have a caterer bring a meal there, but it's not something they charge for. They're not acting as an event center. In fact, I'll show you the, hopefully. So the indoor space that they could avail themselves of is shown here. This is what I think Mr. Geis will refer to as the clubhouse. Generally, what happens in the clubhouse is before people can go on the range, they get a really, really, really detailed safety briefing from Mr. Geis. They're going to get their briefing in there. I don't have a photo of the inside, but I will go ahead and show you the space. So they have had occasions where folks have chosen to set up a tent in this gravel area here on the parking lot. You know, I don't imagine that anybody who wanted to celebrate a first anniversary of their wedding would suggest to their spouse that they use this as a wedding venue or a reception venue. It's not what it's designed to be. So it's merely an accommodation to those who are there for shooting activities. It's not an independently marketed service that they provide. It just, if you're there shooting, we'll let you use the space to do that. They don't charge any additional fee for it. So that's really about all I have to say on that. I mean, we, again, don't disagree that a shooting range cannot be an event center, but the definition of event center is, or special event center, is either weddings, receptions, or reunions, and none of that's taking place, although some folks choose to incorporate a visit to the shooting activities there into their wedding or reunion itineraries over the weekend. So I'm going to yield the floor, if I may, to Mr. Geis, who will treat as a witness. And he can explain to you more about exactly what happens as it relates to those accommodations that they provide to folks who come there to enjoy shooting activities.
Good evening, everyone. So the first thing is, you know, my attorney's already said what we don't do. And we don't host weddings. We don't host, you know, anything really. It's no different than if somebody calls me up and sets the appointment. Perfect example would be Gentry Lock Law Firm, who's been coming out here 23 years. I believe this was their 23rd year. And that's exactly what they do. As a matter of fact, they've had to get permits for the tent for the last 2 years, which was new to us. But whatever. I mean, it was done, no big deal. But yeah, they come out and they do a charity fundraiser for wildlife and veterans, and then they do their own little internal sporting clays tournament, if you will. They have raffles and things like that, of which I have nothing to do with. And then the biggest thing I think they raffle off is a bird hunt at somebody's whatever game facility or whatever. And I mean, Todd's Barbecue out of Buena Vista has been catering for them also those 23 years. We've had Military Officers Association of America come out for the Wounded Warrior Foundation shoots that they do, which is actually not the National Wounded Warriors, it's for local veterans here. And they've used both Todd's Barbecue as well as Mission Barbecue out of Roanoke. And then, I'm going to say it right, Munters. They've done a few things out there, and even before I owned the property, and they've not done catering on that level because their little corporate shoots are not that big, but they've had, you know, food brought out for their folks and whatever. And again, we don't charge extra for the space or anything like that. It's just you're here, you want to shoot. Ducks Unlimited's come out, done that. I'm trying to remember the name of the company. They've got an American branch and they've got an English branch in UK. They've been out about 7 times, I believe, since I've been here or since I've owned the property. And that's really all there is to that. I mean, there's no there. So I don't have any intention of hosting weddings or whatever. So I'm open for questions or however this is supposed to work.
Chris, do we as members, can we ask questions right now?
It may be more beneficial to allow me to respond and then have the rebuttal, if any,
Okay.
and then that would be appropriate time to either open the public hearing, have the public hearing, and then but you certainly have the ability to answer questions before or after the public hearing, or at this time if you feel appropriate.
I did have one thing to add, if it's all right. And it's not up there now, but the changes that we made on the website were, you know, made basically because people didn't understand, I guess, my brevity. As we all know, most people, hell, all of us, you know, how much time do we really spend on an internet web page paying attention to something before we click on something? And that's what I took into consideration when I said pre and post, and that's what it means, pre and post wedding events or whatever it is that you want to do. And thanks to my attorney, we've given a longer explanation, which is fine. But I just wanted to clear that up. I really don't have anything else on this.
Thank you.
Thank y'all. I'm going to stop sharing this presentation. All right, I'm going to make this as brief as possible. I'm going to go through the slides as presented or as planned, I should say, but I will, for timing's sake, make this as brief as possible. Just first off, under consideration tonight, this night's BZA meeting includes 3 separate appeals for zoning administrator's decision. The appeals that are current or that under consideration include the expansion of use of Quail Ridge to include a special event venue, expansion of use to include a private school, and overall expansion at Quail Ridge. The appeals pertain to 3 separate determination letters, and therefore the BZA will be holding 3 separate public hearings. The first appeal under consideration is the expansion of use to include special events. With that being said, in addition, as far as some comments on the record, what is on record, I also would like to note that as y'all know, we have set up a web page or a BZA. Under the BZA webpage, we have a document center, and like to recognize that all those documents on that document center are part of the record as well. First of all, the May 12th, 2023 zoning determination determined 2 things. One, that the outdoor shooting range and outdoor shooting range and a special event venue are separate land uses. Number 2, the grandfathered or non-conforming use at Quail Ridge as an outdoor shooting range does not include holding or hosting wedding. In the June 8th, 2023 grounds of appeal letter, it was stated that the zoning administrator's decision is barred or precluded by the doctorate of res judicia. I know I mispronounced that, meaning that this matter has been adjudicated by the Circuit Court of Rockbridge County and may not be pursued further by the county. The Rockbridge County Court litigation related to a very narrow topic, whether pistol or rifle shooting were separate uses, and changed the character of such use to require a special exception. The court ruled that that the shooting activities or items listed within the definition of an outdoor shooting range are not separate uses that require commercialization and did not change the character of use. The court determined that everything listed under the definition of a shooting range outdoor could be done without a special exception permit. While the court ruling provided Quail Ridge to expand to include the use of rifles and pistols, the court did not allow the Geisers to have any additional uses other than the outdoor range. This slide in my presentation reviews the outdoor shooting range definition per section 302.179B and recognizes that it's a use by special exception. It then goes on to recognize that the special events are also a use by special exception in the agricultural zone, and then further defines as 301.191B. I will skip this portion of the meeting, of the presentation for timing's sake. This just goes over the non-conforming section 708 of the County of Rockbridge Land Development Regulations. And I'll be brief on this. It appears that the Geisers believe, and obviously that's not the case, that they could hold wedding event venues. And what was the mechanism here was not necessarily the language that they had pre and post parties, but it was the statement that we can even host your meetings with shooting involved breaks. Again, the May 12th determination letter states essentially two things. That the use of the Quail Ridge does not include a wedding event venue, and that the grandfathered use did not include a wedding event venue. As the zoning administrator, the conclusion here is the purpose of this presentation is to explain the basis for the determination that an outdoor shooting range and a special event venue are separate land uses, and that the grandfathered or non-conforming use of Quail Ridge does not include hosting special events. These decisions were made after careful consideration. As the zoning administrator for Rockbridge County, I'm confident the decision was logical and correct, and hope the members find the same. Just some comments. I'm going to stop sharing. Just some comments to address some slides that Mr. Kirtner reviewed. Pertaining to the update at Quail Ridge website, the Office of Community Development was informed of this change yesterday, approximately 2 or 3 in the afternoon, and was asked to produce a zoning determination letter stating that they're now under compliance with the regulations. Zoning determination letters are not something that are hastily made decisions, obviously, and we certainly cannot be drafted, vetted, and within 24 hours, especially during appeal process. Mr. and Mrs. Geis received the determination that is under appeal currently on May 13th. 2023. Per the pictures of the clubhouse, it should be noted that the portion of the clubhouse was enclosed without the proper permits nor zoning approvals. This is a direct violation of zoning section 708.04-1 of the Rockbridge County Land Development Regulations that state no existing structure at the time of this enactment or amendment of this ordinance devoted to a non-conforming use shall be enlarged, extended, moved, or structurally altered. Later on in the presentation, or at least included in the documents, you have a YouTube video from March of 2017 that shows the clubhouse as an open-air portion of the pavilion. Obviously, in the pictures presented tonight, that open-air portion of the building is no longer open-air, and that was done, again, without any building permits nor proper zoning. In summary, the letter determined that an outdoor, and it was a zoning determination letter, to be clear. The letter determined that the outdoor shooting range and special events are separate uses, and that the grandfathered or non-conforming use at Quail Ridge does not include the ability to hold special events. Again, as the zoning administrator, the decision was logical and correct. And I hope, based on the evidence tonight, that the members of BZA will uphold the May 12th, 2023 zoning determination letter. Thank you.
Thank you.
Thank you again, Mr. Chair, members of the board. So one of the questions that was asked a moment ago reminds me of something I meant to say to you earlier. So I have prepared remarks, and if you don't stop me, I'm just going to keep talking, okay? And I'm here to persuade you of some things, that the Geisers are not in violation on any of these alleged determinations. But typically, I find that the best method of persuasion is in information to inform you. And so that's really what I'm here to do. So if at any point you want to ask a question, please fire away, because we're probably going to get further with you asking me questions and me up here droning on. So I'll say that. The issue of res judicata, I'm going to get into that in greater detail later. I will say at a high level that it is our position that in the prior proceeding and litigation back in 2018 and 2019, the county either did or had the ability, could have litigated all of these issues that are before you tonight. Now, that's going to have greater impact as it relates to the general expansion of use determination letter. But as it relates to this particular issue, I think our point in raising the issue of res judicata in our initial appeal was, and res judicata is just a Latin term that means a thing adjudicated. Sorry, it's been decided. It's done. Case closed, essentially. And so our point in raising that issue as it related to this particular appeal was that all this information about the VMI reunions, the Gentry Lock visits, Ducks Unlimited, all of that stuff was a part of the record in 2018. And it could have been dealt with then had the county chosen to deal with it. It did not. And again, I'll get into a more fulsome discussion of res judicata in just a few minutes. But this particular, and let me say something else. I mean, I think we're going to have some issues as we go along about what's in the critical path of these appeals. There's not a separate violation letter for enclosure of that that clubhouse. And Mr. Geis will explain to you, what he understood about that and what he did there. Some of you, I think, have been out there. You've seen what was done, pretty minimal stuff. I think you're going to hear a lot of comments about things that the county thinks should have been differently, maybe erosion and sediment control, those sorts of things. Those things aren't a part of any violation letter that they've received. And they couldn't get a violation letter on erosion and sediment control from Mr. Slayton because somebody else deals with that. And he ultimately did get the permits. So I'm going to ask you to really stay focused on what these violation letters, these determination letters actually say, not the extrinsic stuff. I mean, we're going to try not to throw stones. There's some things we're going to have to say that, aren't going to be necessarily very nice. That's the nature of this. But I just would ask you to pay attention to what the determination letters actually say and what we're really here trying to argue about today. And there's going to be some extraneous stuff that's told to you to try to suggest that Mr. Geis is somebody out there just doing his own thing and he doesn't care what the rules are. And that's just not true. And it's not true as it relates to these special events. So I understand that the determination letter merely determines that you can't have the special event use on an outdoor range. But it also says that, and if that were the end of it, I mean, I guess we're not here talking about it. But there's also reference to potential civil penalties if you don't discontinue the use. So we're here to say factually, the things that the determination letter are based on are not true. The only thing that Mr. Slayton had to refer to was that website. There's not a single reference in anything that he's put before you to an actual wedding, a reception, a reunion. There's no evidence of any of that. And so the determination, even though we can agree on the legal theory, which is, yeah, you can't have a special event use on a shooting range. The problem is the legal decision that was made here was underpinned by facts that are not true. And the reason we're here on that appeal is to tell you those facts aren't true and to point out to you that there is no evidence whatsoever in what the administrator, the zoning administrator, relied on to make this determination that any of those things ever happened. It's just the language in the website. And we agree that it was amenable to that interpretation. But that interpretation is not evidence. And that's what this determination was based on. So even though we agree on the law, this determination was based on facts that are not true, and therefore it should be reversed. I also want to say this. I may want to yield the floor to Mr. Geis. I don't know if I can just ask him this question, have him come to the podium, but I want to let him address this issue in rebuttal. Mr. Geis, come on up here. So Mr. Geis, have you ever held any events at Quail Ridge that were not shooting related events. Like
Never.
just people can come and hang out there in the
No.
clubhouse.
No.
No.
No,
Okay.
we don't do that. As horrible as this sounds, my time is important. I'm a full-time student online. I've got two little ones, 3.5 and 2.5. I don't have time for that. I mean,
So we would ask you, based upon the lack of factual support for the zoning determination letter, to reverse that decision.
Okay. I've got a couple questions, if that's all right. I saw on the website, I'm not sure if it cites it now. It says no event is too big or too small. Just how, based on emergency vehicles, if they have to go up to the property, how many people and vehicles, because I know that's a big part of it, Mr. Geis, do you think you could safely host at a shooting event?
it's a great question, and I'm smiling and laughing because you're bringing up something that I talk about in my safety brief. So first of all, talk about safety vehicles, okay? When I brief people that especially have never been to the range before, our range, the Sporting Clays range specifically, is one big circle. Okay, it's about 0.6 of a mile. And I'll just tell you as we say it in the brief, from stations 1 to 4, it's relatively steep. It's gravel, but it's still steep. And if anyone were to ever get hurt, sprained ankle, doesn't matter. Even though that's the closest location to the clubhouse, we will never carry anyone up the hill. I'm also former fire and EMS. But the trail does allow for, and has always allowed for, thankfully no one's been hurt, for an ambulance to actually go down there. I know this because a dump truck to lay new gravel when we first got here was able to do that. And the reason I'm laughing is a fellow sniper of mine who shoots our 22 matches, he actually bought an ambulance as his gun truck that he travels around with, and he drove it up there, and he was just curious. So anyway, that's where that comes from. But to go back further to your question, the biggest event or group of events that we've had is typically Gentry Lock, and they've done anywhere from 80 to 150 people. We have on the one parking area enough parking for 29 vehicles, 3 rows. The main parking lot, when they take it up with the tent, that's why they get pushed over there. We have some of the gentlemen that were here today saw kind of a low area, that grassy area. They're able to park there, and I believe we can get about 20 vehicles in there, and they're not, they get in and out comfortably. And then of course we have, the range itself. So I would say the most amount of vehicles I think I've had was somewhere in the ballpark of about 65, and that's because we try to encourage people to carpool. It's just that some people leave, ahead of other folks. Does that answer your question?
Yes, sir. And I'm just curious of the pre-wedding or pre-reunion events. Do you have many? And when they do set those up, do they arrange it by appointment? How is that determined?
Yes, everything we do is by appointment. I don't let just people walk on, if you will. Mainly it's for the privacy of my family, and if I want to, do something with them, I don't want to be tied to that. But that being said, perfect example of that. Well, Gentry Lock, of course, they just have that first Friday of May every year reserved for them, and because they've had it so long before I came here. VMI alumni send me, pretty much, I guess as their classes form their reunions that they do. And if, for those that aren't aware, they actually set everything up at the Holiday Inn Express, and they have a big beer tent and all that kind of stuff. But the reason that they've been coming out to Quail Ridge for 2 decades or more is because quite frankly, as they tell me, a lot of them don't want to go to the vineyard that I guess is on the schedule, and they would rather go shoot. So they do that. The wives go, I guess, to the vineyard, and they do their thing. But the VMI Alumni Association always sends me out the class names. They confirm with me the dates, and then I reserve those dates for them. So that way I don't have any overflow between VMI alumni personnel and other folks, because it's one big giant safety brief and weapons evaluation I do with those folks. And I just don't have the time to accommodate like walk-ons, if you will. Does that answer your question?
Yes. And then my final question, I was just curious, based on the people, in my experience, you have range control officers and people to help enforce safety. How do you gear that up as your participants? Is there any type of criteria for every 10 shooters? We have one, or how do you determine safety out on the course? Clearly, you can't be everywhere. Do you have a staff?
So when I have those big events, we do. We actually hire trappers, as they call themselves, and they've been working in Quail Ridge long before, again, I owned it. That being said, you have a trapper at each station for the sporting clays, and I'll cover rifle and pistol here in a minute. That is operating the station themselves. That way the shooter is not involved in that part. And then, so of the 17 stations we have, we keep 14 in rotation just to mix things up for folks or whatever, especially if they come here weekly, they get bored shooting the same targets. And it's easier on me than having to go out and actually move anything, which I haven't done in like 3.5 years. So that being said, then we have one floater that goes around. That's basically, the guy that can, who's basically hired all of the trappers to come in or coordinated that. And again, that's not, I'm not paying them. That's all done through whoever the company is or organization that's coming out to do that thing, like Gentry Lock. That's what they've been doing for, like I said, 23 years now. And then I position myself in the clubhouse where all my medical equipment is, AED, defibrillator, spine board, everything that we do normally in the military. And of course, all of my trappers, et cetera, have radios, where normally if just say a group of y'all came out, your group would get a radio. And of course I'm there, and every once in a while I'll go around and just check on the trappers and see how they're doing. And then of course, if we need to refill clays or change a battery out or something like that. When it comes to rifle and pistol, there's always a range safety officer there. About 98% of the time it's me, because it's my range. And, no disrespect to anyone's shooting abilities, I trust no one. And that's just how it is. Even if you've been training with me for a long time, it does not matter. The liability is great, as I'm sure everybody would agree. And I mean, I live on the property, so there's that. But there's always somebody there. And, those are our standards, and they don't change whether you're a normal, everyday Joe citizen or a military member or police officer. And I get that a lot on the phone. Do I have to go through your brief? Do I have to have a safety officer there? The answer is yes.
Thank you. I don't have any further questions for Mr. Geis. Other board members before we open it up to the public? Okay. If
I might have a quick question, but I think can I only ask Mr. Geiser's attorney questions at this point in time, or can I ask Chris you questions?
I think it's appropriate to ask any of us.
Okay.
Yes, sir.
The question I'm thinking of before we start the public hearing is what constitutes a special event? Because if what I hear Mr. Guy saying is he's hiring or he's renting out his space specifically just for shooting and not charging for a gathering beyond that.
So
I want to
again,
get clarity there, because you could take any business theoretically and say like, okay, you're this business that, I don't know. I don't want to get into a vagary, but it seems like he's not in the business of special events. He's in the business of scheduling shoots. And the question we're starting to get into is like, should we limit seems more like a zoning question of the size of the shoot, because he's not charging for the event.
Sure. And that goes back to the fact that, this would have been a great discussion to have at the beginning of May. Mr. and Mrs. Geis received these letters on May 13th. They appealed them on June 9th, I believe it was. And so I'm not in a position to, again, draft a zoning determination letter. And that's not the purpose of this hearing, is determine if he's still in compliance or under compliance now or not. The purpose of this is, the May 12th, 2023 zoning administrator's decision that is currently under appeal. And I'll remind everyone, they had the right to withdraw this appeal, but they chose not to. So we are acting on this appeal. The appeal determined that an outdoor shooting range and a special event venue as defined are separate land uses. And number two, the grandfathered or non-conforming use at Quail Ridge as an outdoor shooting range does not include the ability to hold or host special events. Now that is completely different unlike the website alluded to yesterday, excuse me, on Monday of this week, that you can do shooting as well. They obviously have the ability, and we'll get to that. I think it's a more appropriate time to have most of this discussion during the third and final public hearing. But with that being said, that those are the two determinations that I request that y'all uphold.
Thank you.
Oh, okay. Anybody else for any questions from the BZA?
I have a quick question. If this is all about a misunderstanding in the wording on the website or intention with that, why wasn't it cleared up sooner? It seems like it was, you're saying it was a simple misunderstanding. Is that correct?
I think a pretty simple.
Why did we get this far and not deal with it sooner if it's a simple mistake?
We probably could have just clarified the website sooner. I don't want to get into a lot of conversations with council. I will say that, there were some discussions where I said, I think we can get this part of it cleared up. Okay. But as far as changing the website and just clarifying it that way, I mean, I suppose that's on me. Mr. Geis followed my advice when I gave him that advice. Why we didn't just think to just do that sooner and solve the whole problem. I can't, I guess, again, that's on me not getting my brain around it a little more quickly. And that's the nature of hearings. You spend time around lawyers very much, you find out that lawyers thinking about things crystallizes a whole lot in the last few hours before a hearing or a trial. That may be an occupational flaw, personal flaw maybe, but it's not because there was any question about whether he was ever going to try to do these events. I mean, again, without getting into a whole lot of details about conversations with council, there were some conversations about, I think this is one that we can probably get cleared up. Probably should have cleared it up more quickly. And I understand why Mr. Sladen felt like he didn't really have time to do a new zoning determination letter. But again, we get back to the question of what the determination was really based upon. And we said in our appeal that it was based on inaccurate facts. And we didn't try to detail all those inaccurate facts, but we did say in the written appeal that it was based upon inaccurate facts. But to your point and your question, that I think is just a function of lawyers thinking hard about things when hearings approach, to be quite candid with you.
Thank you.
Okay. At this time, I'd like to open it up for any public comment. I ask that you introduce yourself and you stick to a 3-minute rule. In my absence, I've asked our co-chair to time and indicate when you've had your time. Anybody joining by web, we already had gone over the procedures. Just hit the raise hand button.
We have a couple physical people like to sign up before we recognize those online. The first up is Mr. Hunter McCoy.
Apologize to you, gentlemen. I forgot my hearing aid, so I haven't heard hardly anything that's been said on that. But I have Chris Hall, the original owner of Quail Ridge, opened up that range in 1992. I've been shooting out there since 1992. There have been corporate shoots since that time, but I've worked as a trapper, what they call a trapper that Mr. Geis mentioned to you. Chris originally had a leg where we shot once or twice a month in that leg for quite a few years. I think that continued for a while, but I was unable to compete after, I think, 6 years, somewhere in the late 90s, 6 or 7 years. And I'll get into the, also mentioned as far as the rifle and pistol ranges go. Now, I never shot on either one of those ranges. I was present several times when there was rifle shooting going on. And then I have worked a couple of times, worked for Mr. Geis out there where he had his 22 shoots as a safety officer. And I have to say on that, there were quite a few of us there. So basically what I'm telling you is that I don't know about these special event things I hear talking about, but there have been corporate shoots there, league shoots there ever since 1992 on that. So any questions?
No, sir. Thank you.
Next up is Mr. James Maxwell.
Mr. Chair and members of the BZA, I know that you'll have to stop me because I'm not timing myself, so please do. My name is James Maxwell, and I own the land directly south of what was Quail Ridge Sporting Clays, now Quail Ridge Sporting Club. And we bought that farm in 2010 and immediately started to clear the land and to build cattle facilities, fences, and many more things. I worked there physically every day, 6.5 days a week. Very rarely was I gone. And during that time, I had a great opportunity to see, hear, and know what Mr. Saab was doing. I'm also a lawyer prior to, and was working as such. Prior to buying the land, I looked at, researched, talked to local folks, talked to Mr. Krickenberger, the zoning administrator, and to find out exactly what was grandfathered there, and with my own eyes and ears saw that. Over the course of time, I listened all those years, and I'll add more other moments when I get to speak to the other issues that'll be brought up, specifically as to the wedding receptions, reunions, or events. During Mr. Saab's time, there were a few 4 to 6 organized shooting events a year. I know that because the shooting stations are 40 yards from my fence. I knew that before I bought it. And there was 1, 2, 3, 4, 5, 6. Sometimes when the leaves are off, you can see 9. Because of the loud noise, I know when it's occurring. You can hear it all the way across the farm. With respect to those events, I never was aware, certainly was never advertised by Mr. Saab they had any wedding events or otherwise. Mr. Geis spoke of Gentry Lock. Gentry Lock has been shooting there. Gentry Lock does set up a large tent. There is food available. I disagree with Mr. Geis in that early on, Mr. Geis advertised on his webpage that they would also provide meals, home cooked things, pots of chili, hamburgers, and things like that, and posted pictures of those, which I had gotten at that point and maintained. I believe that was 2017. I don't have those with me. As we speak on other matters, keep in mind, I'm sorry, I don't remember the attorney's name, but the issue of res judicata was brought up. It's a legal point, as he described. Please keep in mind that this is a moving target, to use that term specifically. Mr. Geis's business model changes all the time. And what he advertises and what he does changes all the time. But with respect to the wedding venues and so forth, that's been advertised for quite some time on his website. And I think that he's bound by those words. Bound by those words in the sense that he's a shrewd businessman. He advertises what he's doing, and then they come out and those folks do those things. I think it was specific and not an accident. In order to get to the property, there's a long driveway. The area is pretty much secluded. I will say that in 2022, winter 2023, he's had a large area logged in the center of the property, not far from my property. You can see it from various points on my farm, approximating its 2+ acres that's been cleared. Its view will be to the west and will be a lovely spot for wedding venues and things like that. Thank you.
Next on the list is Mr. Chevy Volpe.
Chairman, I see there's a chair there and don't see you, but my name is Sebi Volpe, just for the record. I am a local minister, been a minister here for a long time. I have shot at Quail Ridge a bunch. I'm also Mr. Geis and Mrs. Geis's pastor. And I also have a background in law enforcement. I have a background in private investigating. Prior to me coming here as a pastor, I've also been a police chief in West Virginia for a number of years. And I'm coming to just speak to this particular issue simply because I feel like part of the reason why it took all the way till now to start talking about what was actually said or written on the website was because when you say you can't have events, the immediate thought for Mr. Geis is, can I not have or hold shooting events? Meaning shooting events that include Gentry Locks deal or the reunion or any of these other things. And so I don't even think tonight we've been specific enough to say what kind of events can we hold. He's never held a wedding, not planning to hold weddings, but if a wedding party wants to come and have their party, you know, to shoot, they want to shoot there and they want to have their folks come out and shoot. Their wedding venue is, let's say, House Mountain Inn, but they want to come there and shoot and have something to eat and bring their own food. Is that going to be, you know, by this determination, is that going to be no longer allowed? Is Gentry Lock no longer going to be allowed to come and bring food? Is that what we're talking about when we talk about events? I mean, I think the biggest issue here is to clarify, and the reason why the attorney was taking so much time to look at this is that what we're talking about here? Are these events that have been going on for 25 years now going to stop simply because they've determined that he can't have events there? Say it's wedding events or say events. It was not real specific in the determination letter what kind of events we're talking about. The word event was used several times. So I'd want to make sure that the clarification is made in y'all's decision here, whether to uphold or not uphold. Can he have events that are directly related to shooting? And if he can, and those events can happen, he's not charging for the other activities that go on while the event's there, then he's really just doing that out of the kindness of his heart, and he owns the property. It's not like it's part of his business model, as Mr. Maxwell just alluded to. His business model has never changed. Everything he does there is related to shooting events. And I just want to make sure when you guys make your determination that we get very much clarity on what does that mean for the future. Thank you.
Next up is Mr. Scott Miller. Thank you, sir. That's all that's signed up now, but we'll recognize anyone who would like to speak at this time. Not seeing anyone down here. Stefan, I believe you're the host. If you can recognize any attendees with their hands up or who would like to speak.
Nobody's made a comment and a hand did just go up. So I believe it's Martha Hust. I will give her the talk. You just have to unmute yourself, Martha.
Am I unmuted?
You are?
Yes, we hear you.
I am Martha Hust. I own adjoining property to Quail Ridge. We share approximately 3,800 feet of frontage of property line. Prior to 2017, Quail Ridge was little more than a glorified hobby, 99% of which was sporting clays, happened 2.5 days per week. Many scheduled days, there was very little, if anything, going on. There were only a handful of organized shoots yearly. And that is what our community grew accustomed to. When a non-conforming use is grandfathered, it's not meant to grow from a glorified hobby into a full-time endeavor, as the current owners are attempting to do. You've heard a list of what they are now offering, what's now on their website. I want to point out that Quail Ridge is, and you've also heard the number of attendees that he has. I want to point out that Quail Ridge is located on a narrow gravel road. The entrance to Quail Ridge is on a curve. The site distance to the southeast when exiting the facility is non-existent. Vehicles leaving Quail Ridge must stop prior to entering the state-maintained road to avoid accidents. Many times this is not happening. I've almost been hit by a vehicle leaving Quail Ridge without stopping, as have others. Additionally, I've been working on my land across the road from the Quail Ridge driveway, and I've witnessed vehicles rolling down that driveway and onto the road without stopping. It's a miracle there hasn't been an accident. It's only a matter of time. The website states there is no additional fee beyond the fee for shooting activities. However, on the website, the rifle and pistol range is offered for rent for guest instructors, law enforcement officers, military, government agencies, other private gun clubs, and corporate, charity, and organizations and groups. This type of activity is something that needs to be regulated. which is one of many reasons there's zoning regulations and ordinances. Ducking and dodging and playing word games regarding what's offered at Quail Ridge does not negate the fact that the current owners have expanded the offerings way beyond what was happening on that hill prior to 2017. And they have a history of doing as they please, not what is allowed. The increased activity is not only disruptive to our community, but the uncontrolled traffic is a danger on our little road. That's all I have to say this evening. Thank you.
Thank you.
Thank you, and sorry for the mispronunciation, Miss Houston.
Okay. You
Any
know,
other- Any other hands
Heather?
there, Stefan?
That was the only hand that I saw. I don't currently see any additional hands or anybody who's left anything in the chat.
well, I've had a few passive thoughts listening to everyone, and I've just got a couple of questions.
Mr. Pufall, Chairman Pufall, may be appropriate to close the public hearing if you're ready to do so.
Oh, yes, sir. Yes, thank you. If there's no other questions, I'd like to close the public hearing. To Ms. Hughes' point, Mr. Geist, about the traffic and her concern, is there a stop sign at the bottom of the drive? And or would it help if a mirror or something were put up?
Well, there is a mirror there, and that claim is, it can't be proven. I mean, she's already testified she doesn't even live there and frequents it like 50, 70 days out of the year because she lives in Northern Virginia. That being said, there are logging trucks on that road. I mean, we could go there if we really want to, but it's not for my property. I mean, hell,
Right,
the braking bumps alone prove that.
I guess my question was, is at the base of the driveway up to your property, is there a stop sign?
There is not. I mean, if
Okay.
it's something that we need to do, we could do it. It's not a big deal.
It sounds like it'd be the right step, at least to safety for others that travel on the road.
Sure.
And then, I noticed that you do have the sign 7 days a week, and your pastor had indicated you're a man of God. Is there any reason why you wouldn't change your Sunday hours to maybe start, instead of saying open 7 days a week? Maybe your neighbors would feel a little more comfortable if you put 1 o'clock till sundown on Sundays or something similar. I could certainly understand as a neighbor, just something to consider.
So you're asking me a question that pigeonholes me into a corner, if we're being honest.
I appreciate
The answer is, yeah, I could. But the real answer legally, specifically, is that those that have, bought property next to the gun range knew that moving to the nuisance. That's literally the law. And I'm sure we're going to we've already heard about noise and things like that. The state already exempts any shooting range from noise 24 hours a day, 7 days a week. And even this county's regulations, because they cannot go any stricter than the state. Also, whether I don't understand why they continue to call our range a special use permit, considering it was there long before, even when they tried to get rid of all the ranges in 2007 and failed. But regardless, their regulations, the county's regulations specifically state business, industrial, special use, etc., are exempt from all noise. So, I mean, I'm not accusing anybody of anything. And yeah, I might consider that. And I mean, if we really looked at, the hours that we do anything on Sunday, I mean, there's really not really anything going on that morning. As a matter of fact, those are days that people don't call in because they're in church or what have you. And if I'm not at church, I'm probably making up homework. But that's the reality of it. But again, you're asking me to do something while I'm standing here being accused of things I haven't done.
I understand. I just was mentioning it as maybe a step in the right direction to
Yes, sir.
just help. Thank you.
Chairman Pufall, if it's appropriate, if I may address the board, it might save some time.
Yes.
So as far as the question is, that there's a third zoning determination under appeal this evening. And that determination letter, it recognized Quail Ridge was grandfathered to hold advertised shooting matches and organized shoots. This could include shooting matches, organized shoots for corporation, fundraiser, and charity events. I want to apologize essentially to everyone here because this is not the time nor place to have this type of discussion. This is an appeal. It's appeal on two different things. Again, it's the shooting range, a special event venue, are separate land uses, and grandfathered or non-conforming use as a outdoor shooting range does not include hosting or holding or hosting special events. This conversation would have been very beneficial to have a month ago, even in fact about a year ago, because I have talked to Mr. Geis directly about special events and the process moving forward. So with that being said, I'll turn the floor back over to the chair.
Thank you. Okay. What, Mr. Geis, did you have something you wanted to say?
We've never had a discussion. I don't talk to you.
Okay, that, I'm sorry, it's all right. Sorry, yeah. Okay. All right. Well, at this time, we've got to make a determination on Mr. Sladen's Mr. Sladen and the Geis's appeal. I am the board, anybody would like to make any motions? Is the chairman allowed to make a motion, Chris?
Vicky, Ms. Huffman is shaking her head in a no manner.
Okay, thank you. Thank you, Vicky. I'll look closer.
So to clarify, I'm potentially making a motion to,
You would be either in support of Mr. Sladen's.
of Mr. Sladen's determination that there, from back in May, that there is a difference between the grandfathered use of a shooting range and the use for special events as defined in the zoning. And could you remind me the second motion, just so that we're all clear on the two things?
So I believe
Sorry,
Ms. Huffman has passed out some draft motions. That would be some draft motions with findings to affirm.
Yeah.
And I believe she's, or to reverse the motion with certain findings. And the other one is to delay action.
I want to make sure I understand
apologize.
the two things, because I think as I'm new to the BZA, but as I understand the conversation thus far, we've started to get into other topics tangentially beyond the two things we're specifically talking about in this portion of the meeting. I could be wrong about that, but that is my understanding up to this moment. So look at this real quick. Yeah, so the two determinations we're talking about in this portion of the meeting are that a quote shooting range outdoor and a quote special events are separate uses. That secondly, that the grandfathered non-conforming use as an outdoor shooting range does not extend to provide the ability to hold special events. The only thing I'm thinking about, and I don't know that this is our role at the BZA, but maybe this is back to the planning and zoning, is with a shooting range, are they allowed to have people that come out and shoot that hire in catering? Does that suddenly become a special event? And that, again, I just went through the BZA training course with the state. As far as I understand, that is not our determination to make. It's simply about these two zoning issues. Vicky, if I'm wrong about that, but okay. Thank you.
I guess from my perspective, if communication with Chris could have prevented this right now
Mhm.
in advance. But based on the knowledge from what I see of what Chris saw in an advertisement, that it was being advertised as a non-conforming use.
Mhm.
And that's basically what we're here to decide.
Well, we can have discussion now, correct? Between us? Yes, okay, just confirming. So I'm of a mind to affirm. I just also don't want to make sure that that doesn't pigeonhole Mr. Geis as to other things, other specifics I might not be aware of. I'm affirming, like now the barbecue company that the VMI class has been hiring for decades can't come up there, or something like that. As I see these two determinations right in front of me from, Mr. Sladen, I'm inclined to affirm. I just don't know the details of special events, and I don't want to affirm this determination without knowing for certain that I'm not also taking something off the table that has been done there in the past. I'm
And I
pretty
would
confident we're
have to
not
ask
doing
Vicky,
that.
but basically, we're just affirming or overturning Chris's decision that it's not conforming, correct?
Is that at that time and not speaking to as of today when the website has been changed without that one piece of evidence?
My
Okay.
feeling is if this were a bowling alley and I were advertising for my bowling alley that you could have a bowling party or if this was a skating rink, even though its primary use is for bowling and the primary use is for skating, if I decided to invite my wedding party to go skating, would I need a special permit to do that? I mean, if I'm not renting a hall and I'm just bringing them skating or I'm bringing them bowling, there's no special fees for having the event, then that's what I'm trying to get my hands around is what constitutes an event. I don't, I think websites can really say anything they want. And in as much, I think people take a lot of liberties, and I can understand Mr. Sladen's interpretation, but I also go to a lot of different websites, and a lot of websites to pull you in say a lot of things that and they use a lot of words, no event too big or too small, when that's just not true. But it's the wording we use to help our business. So how do I fault Mr. Geis for using that? I can't. But given the interpretation, I completely understand Mr. Sladen's position on this situation.
I don't know if it helps you all any, but special events is defined in the land development regulations. It is venue for weddings, reunions. This is the third one.
Is that the same? Is that would be used synonymously with conditional use permits?
Well, I think I'd be better to address that one. So both of them are used by special exception in the agricultural zone. That would be a shooting range outdoor and a special event is how it's defined. With that being said, it is clear that the later, the third and final expansion letter, again, the determination letter recognizes that Quail Ridge is grandfathered to host advertised shooting matches and organized shoots. This could be shooting matches, organized shoots for competitions, fundraisers, and charity events. And so that's, or corporate. In some cases, Mr. Geis has talked about Gentry Lock, and that would be essentially an organized shoot, essentially. And so we are on the same page, and I can say that publicly as far as the difference between an organized shooting match and an organized shoot versus a bona fide wedding. With that being said, I'll leave it at that.
I think that all this has helped clarify for me. I think that that for this first one, it seems a lot more straightforward to me that I make a motion to affirm the zoning determination that a shooting range, outdoor, and special events are separate uses. That's already clear in the zoning. And that the grandfathered non-conforming use as outdoor shooting range does not extend to provide the ability of holding special events, as you just specifically clarified. Special events would be, you're not coming up there to shoot, you're coming up there to have a wedding, and the shoot is secondary. Oh, that the decision of the zoning administrator is correct.
A second. I second.
All in favor?
Aye.
Aye.
Opposed? Aye.
To clarify, that's a 3-1 vote with one opposed.
Yes, sir.
Mr. Pufall, would you like to introduce the next appeal, or would you like me to?
Sure, I can do it.
That would be
Scott-
number 6 on your notes.
Yes, sir. Scott Geis and Crystal Geis, 336 Morat Road, Lexington, Virginia, 24450. Application to appeal the May 12th, 2023 zoning administrator determination on the grandfathered or non-conforming use at Quail Ridge Sporting Club as an outdoor shooting range does not include the ability to develop and operate a private school paramilitary training facility. Mr. Sladen, will you please read the advertisement?
Absolutely. Notice is hereby given per section 15.2-2309 and 15.2-2204 of the Code of Virginia and section 808 of the County of Rockbridge Land Development Regulations that a public hearing will be held by the Rockbridge County Board of Zoning Appeals on Wednesday, July 19th, 2023 at or after 7 p.m. in the Board of Supervisors meeting room in the County Administration Building, 150 South Main Street, Lexington, Virginia, 24450, to consider the following application. Scott G. and Crystal Geis, 336 Murat Road, Lexington, Virginia, 24450, has made an application to appeal the zoning administrator's decision, appeal the decision of the zoning administrator. On May 12th, 2023, the zoning administrator determined that the grandfathered or non-conforming use at Quail Ridge Club as an outdoor range outdoor shooting range does not include the ability to develop and operate a private school / paramilitary training facility. This decision is under appeal. The property is identified as tax map number 73-A-17 and consists of 84.21 acres per tax records and is located on the east side of Murat Road. Further identified as Route 675, approximately 0.67 miles north of the intersection of Murat Road and Collierstown Road. Property is located in the Carrs Creek Magisterial District.
I got my looking for, right?
First one.
That's it. Thank you again, Mr. Chair, members of the board. Whatever disagreement we may have about outcomes, we do appreciate the careful way that you're considering these things. They're complicated procedurally, and I know you don't get to do this every month. It sounds like these are pretty infrequent, and so we understand that, and I hope maybe I can do a better job on the procedural aspects of this appeal than perhaps I did on the last one, and if so, and I hope so. So in that vein, I kind of want to skip to the end in a sense before I get started, kind of at the outset. And so, in this last appeal, we kind of had this discussion. Well, we're not really, kind of sound like we're not really saying you can't do this, even though we kind of think you were doing this special event thing. We're not really saying you can't do it, or we're not really saying you can't do what you've been doing. We're just saying generally you can't do a special event. And so I want to make sure we don't kind of get into that tangle again this time, because, I would ask you to take a look at, if you have it, the zoning determination letter here, which talks about private school and paramilitary facility, which I don't actually think is any sort of defined use in the regulations, but certainly private school is, and we're going to talk about that. But the zoning determination says it's been determined that the grandfathered non-conforming use at Quail Ridge's outdoor shooting range does not include the ability to develop and operate a private school slash paramilitary training facility. Then it goes on to say include the things you can't do. Okay, so it goes a little further than the last appeal we're talking about, and I think that's important so we don't get in this tangle again of, well, we're just saying generally what the non-conforming use doesn't allow, but we're not saying you're necessarily doing that, or we're just saying this is what the non-conforming use doesn't allow. So here it's pretty specific that there are certain things that they're telling Mr. Geis and Ms. Geis that you can't do on your property because we view those things as a private school. And apparently paramilitary training facility, again, I don't really see that that's some sort of defined use in the regulations, and I would reject the notion that that's what's going on there. But so here, if there's a determination, they're asking you essentially to determine that this is a private school that requires a special exemption or special use permit. So with that being said, we're going to talk about instruction. Every type of instruction that Mr. Geis provides at his facility, at his shooting range, involves a shooting activity. Every one of them. And it's ultimately focused on how to safely handle firearms in various settings. It could be, shooting at a distance on the rifle range in view of potentially hunting or competing in some sort of rifle shooting event or sport. It could be simulating being in your home and doing home defense. But every type of instruction involves a shooting activity. And that's important. And it's important because now we got to talk about what happened in 2018 and 2019. As Mr. Slayton has already said, the decision that was reached by the Rockbridge County Circuit Court, ultimately affirmed by the Supreme Court of Virginia, among the things that it said was that the things that are listed for an outdoor shooting range, all those activities, whether it be archery or rifle or shotgun, whatever it is, those activities are not separate uses. They're all activities within the use of a shooting range, okay? And that becomes pretty important as we start talking about the school, because what they would have you to believe, or what the county would have you to believe, is that if Mr. Guys incorporates instruction into a shooting activity, suddenly it's a different use. It's a school. That's essentially the argument here. And I am aware that the zoning determination letter acknowledges that there are some types of, or they would allow certain types of instruction, basic safety instruction, I think is what they said. But all shooting activities are within the allowed use. And every single one of these activities that we're talking about, types of instruction is involving a shooting activity at some level. You know, common sense is probably telling you, of course, that just because you incorporate shooting, or excuse me, instruction into a shooting activity doesn't make it a school. It's still a shooting activity that's allowed on an outdoor shooting range, which is the non-conforming, allowable, grandfathered non-conforming use. Instruction is not just incidental to the operation of a shooting range, it's integral. We want people who are operating shooting ranges to be providing good instruction to the people who are handling firearms and firing weapons on their property. The testimony of a couple witnesses that we'll put on, I think, will be that every single shooting range has an instructor. There's a range instructor, there's a range safety officer. There's somebody there at every single range to say, or to provide instruction to folks who are on the range. That's true of Quail Ridge. It's always been true of Quail Ridge. The first slide I think we have for you, Mr. Saub, who was the gentleman who owned the property previously. This is his certificate as a level 1 shooting instructor through the National Sporting Clays Association. So I think the testimony would be that Mr. Saub, and there's some testimony already in the record that's been provided to you, that Mr. Saub was a shooting instructor and provided instruction in sporting clays and probably actually in concealed carry use as well. There's also an affidavit from Mr. Saub that's behind tab D in the notebook that I provided to you. In paragraph 3 of that, he said he lawfully sold rifles, pistols, and shotguns, and as a certified instructor, provided customers with instruction in each of these 3 disciplines. So that's been going on. That instruction has been provided long before Mr. Guys bought the property. The only thing that's really happened since then is Mr. Guys, I think some folks would say, is a safety instructor on steroids. And so he's enhanced the safety instruction, and he provides other types of instruction too, but all related to shooting related activities or shooting activities. And so, you know, we're going to talk about the law a little bit, but I think it's fair to ask you to engage your common sense on this definition. So we need to talk about the definition of a school. So the zoning determination letter relies on Webster's dictionary's definition of a school. And so the applicable zoning regulations require that in order to operate a private school in this particular zone district, you would have to have a special use permit. So the definition of school that the county chooses to employ and rely on is an organization that provides instruction. Well, that's very broad, obviously. And that could sweep a whole lot of folks, a whole lot of organizations into the definition of school. And I ask you to really think about everything that would be swept into that definition of school if you accept that definition. There are lots of retail establishments around, restaurants, that to engage their customers in using their services or buying the things that they sell, advertise schools, looking schools. I'm going to come back to that one. Here's an example. Lowe's, which I guess there's a Lowe's here in Lexington, it's my understanding. They advertise workshops that provide in-store events. They provide training. They invite people to come in and get training. And so I'd ask you, I mean, does that transform Lowe's into a school? That's not the core of what they do. They're a retailer and appropriately licensed or regulated and zoned as a retailer. The fact that they provide instruction as a way of engaging with their customers, does that transform them suddenly into a school? And to hit something that's maybe a little closer to home, you know, the county, oops, that didn't work. It doesn't like it when I try to go back. Got any advice for me here, Mr. Slade? Well, oh, I hit up here. Okay, I'm sorry. I hit up. Yeah, okay, all right. Thank you. Appreciate that. Helps if you hit the right button. So, okay, so let's look at that one. So back in 2014, the county okayed a training facility, an outdoor shooting range for the sheriff's department. Now, I don't presume to know all the communications that have gone on between Mr. Sladen and the sheriff's department. You know, maybe he sent them a zoning determination letter that said you can't be a school. But I imagine most of you would be surprised if there's been that kind of communication. And probably most of you would be surprised if the county views the shooting range that's operated by the sheriff's department, which says that it's going to have training facilities and a classroom and a training area, as a school that can't provide instruction in firearms handling to people who are there to engage in shooting activities. So what I would suggest to you is that there's a rather selective interpretation or application of the definition of school here that's being applied to Mr. Geis's situation and not to others. And we wouldn't want them to apply that definition to Lowe's or for that matter to the sheriff's department. I believe the testimony will also be that the sheriff's office is doing SWAT training. Now, we take issue with the use, Mr. Geis or Mr. Sladen's use of the phrase specialized training. I mean, I don't know where that term came from. I don't think it's necessarily a term of art in the shooting industry. But if there is specialized training, certainly SWAT training is specialized training. So this body and the county would really have to apply the same definition to the sheriff's shooting range if they want to be consistent in the application of the definition that they're trying to apply to Mr. Geis now. And again, I don't know about all the communications. Frankly, I'm not exactly sure what zoning district that particular facility is in, but I would just suggest to you that the county probably doesn't view the sheriff's department shooting range as a school. And the next slide is the letter from Mr. Krickenberger, who was the prior zoning administrator, who notified the sheriff's department that they had been approved for a shooting range for law enforcement training needs. So Mr. Geis operates a shooting range that is a grandfathered use. That's been determined by the court. And him doing the same things that are done on other ranges in the county does not make it a school, private or otherwise. And I'm going to yield the floor, if I may, to Mr. Geis and then to another witness so that Mr. Geis can talk to you about the training that he does provide on his property.
Gentlemen, if I may, I think some history is needed here. Okay, mainly because respectfully, you guys have never seen me before. All right. And the only person that has is Mr. Poofel. And I'm not sure exactly how much, he remembers from the last BZA hearing. I came here a week prior to closing on the property to specifically talk about what I was going to do with this property, to make sure that it was a grandfathered outdoor shooting range with no limitations. That meeting happened with myself and Sam Kirkenberger and Mr. Chris Saab. After that was uncovered, when it was denied initially in deposition, that kind of got settled to a point. The county, for whatever reason, and this board specifically, and I've already talked to Mr. Poofel about this in the past. Well, Mr. Poofel asked me back then if I would provide him my resume. Okay. If you don't know anything about me, and you may not have it in front of you, I've been a special operations Marine almost 30 years, both in the Marine Corps, retired, as well as contracting overseas in Afghanistan, doing the same job I did as a reconnaissance Marine and sniper. Something that the paper loves to throw out there and endanger my family with. Thank you. Because that resume, while yes, it, I guess legally could go into the hands of the county, found its way to the paper. So why is this important? Because Mr. Kirkenberger and I in that meeting knew exactly the kind of person I was. I addressed exactly what happened in that meeting. I even showed the documentation that he gave me regarding the Natural Bridge Boys Home they were trying to sell for about 15 million something. To his words were, you may be interested in this, after I explained exactly what I wanted to do. Paramilitary training for both military, law enforcement, and at a discounted rate for civilians that wanted that training. He handed me this document. I'm new to the county. I don't know anything about the Natural Bridge Boys Home. Okay. I think it's like, I don't know, 12 or 15 pages or something like that. Still have it on my desk. And he told me that other people with my background wanted to do the same thing that I wanted to do here. So it's important to note that this discussion happened and they knew fully well what I intended to do here. And I asked why it didn't go through. We're just having a conversation. No motive, no reason really, other than why it didn't go through. And he said because pieces of the facility had been pilfered by other county departments, and that a decision to sell it could not be reached, or I'm sorry, an agreement on the price cannot be reached. Because yeah, if I had my way, I'd love to have, an awesome shooting facility with a cafeteria, bunkhouses, all this kind of stuff. It's not in the cards for me. I'm too old, got little kids, like I said, and doing other things. But this place offered all that: cafeteria, gymnasium, fenced in compound. I mean, you could literally do school shooter training like nobody's business there. It was amazing. But I didn't have $15 million to buy it, of course. And so it's important to understand that this is not all new. This is not, Mr. Geis over here just randomly doing whatever he wants to. All of this was my understanding before I closed on the property, as dated in the grandfather letter that I had to specifically ask for prior to my closing February 1st, and that letter dated in January. So that being said, I hope gives enough history for that. Central point here to be made is that instruction and training, as my attorney said, are incidental to running a shooting range. They are a necessary part of range operations. Like I said, you don't assume anybody knows anything. And again, not disrespectful to anybody, but I don't care how long a person's been hunting, how long they've been in law enforcement, how long they've been in military. These skills are perishable. And if anyone were to say otherwise, they're being dishonest to themselves, let alone the process. Yes, I am a safety Nazi and on steroids. All of the training and instruction you provide, or I provide, pertains to the safe handling and discharge of firearms. That is to say that all of it pertains to shooting activities. All of my patrons get some form of instruction in a detailed safety briefing. That briefing is almost an hour long, to include videos that show what happens when things go wrong. I can guarantee that anyone here that's ever been to an indoor shooting range most likely never got a safety brief, or sporting clays range. You went and signed a waiver, got a card or a way to participate, and you went on your way while an RSO looked over your shoulder. That is not what I do at my range. Patrons who want other types of training are not required to enroll in any school or pay a tuition. They merely pay for an hourly fee for me to train, and that's true. I've never advertised this at a school. And if we're going to get into, words and things like that, as someone else alluded to, words have meanings. I was a special operations instructor as well. I'm sorry if one of my habits is calling somebody a student, if that's where we're going with this. Okay. But again, I've never advertised as a private school, and it's done on an appointment basis only. And as my attorney wanted to ask me briefly today, how does that go about? If somebody wanted, for instance, close quarters battle training, okay, the first thing I would tell them, well, there's a workup involved. This is not something that you just, jump into, mainly for my own safety, let alone theirs. Okay. Some of the training that people do, and I'm not sure how familiar you are in the shooting sports, so I apologize. But some of the training that people do, it is or looks to the outside eye that has no idea, whatever, special in nature. I don't know if your computer did something. Anyway, special in nature, SWAT related, CQB, whatever, all the sexy terms that people like to try to use. And of course, as the zoning administrator and others here have tried to point out, 3-gun, steel challenge, all of those types of things, they're all sports, shooting sports, and they're all centered around that type of tactical training. They're not standing out there just like a normal person would at an indoor shooting range. And to be quite frank with you, a lot of the indoor shooting ranges, Safe Side Tactical, for instance, it's right in the name, okay, at Roanoke, offers tactical training courses. It's the staple of shooting ranges. And again, someone with my background, it'd be ludicrous to assume that I wouldn't want to, use that as my skill set. So yeah, they request and receive, the training I do prepares them for shooting sports such as 3-gun and long range rifle competitions. Some of the training I provide is similar to what county and city SWAT teams now receive at the county shooting range. I've had, before the last BZA hearing, I did have Roanoke County and City SWAT snipers there. They went through a full firearms workup before we ever got to their specialty. And 2 of them actually testified to, what happened. All the shooting ranges always have a range instructor present. And not only was Mr. Saab, an NSCA or National Sporting Clays Association level 1 instructor, as I am myself, which, by the way, if we want to be talking about specialty training, how many here have shot a moving target before? How do clays fly? Varying presentations, varying speeds, varying distances, that kind of stuff, right? Most people don't shoot moving targets. They wait for a deer, if you will, to stand still and then they shoot it. And hopefully they're never in an actual situation where they have to defend themselves. But that's what we do. We prepare people. He was also a home defense instructor. The guy has almost as many NRA certifications as I do. And the only thing he's missing is he's not a chief range safety officer, which is the highest level I can go under a training counselor, because you can only have so many in square miles. Everything I do is predicated around safety. And it doesn't matter if you're my friend, if I know you, offline, off the range or whatever, it doesn't matter. Once you step foot on my property, it's a different hat and I'm a different person. And that's how it has to be. My wife is actually one of my students, if that tells you anything. How many men can say their wife will listen to what they tell them? All right. So I need you to understand that this is what's really going on here. And to limit paramilitary or whatever, try to label anything specialized instruction, not to be facetious here, but I mean, my gosh, gentlemen, some of you are new to the board. As you guys said, you barely, do this once a month or something like that. You're receiving literal instruction from the people here that have been here longer to instruct you on how to perform your duties today. That's all I have, unless you have questions.
Absolutely. Yes, sir.
Okay, Chris,
Yes, sir.
do you, was there any rebuttal that you would like?
They have another witness.
Okay, oh, I'm sorry. Thank you.
Mr. Chairman, I've already stated who I am and how I'm related to Scott as far as his pastor. And I also talked about some of my past experience in law enforcement for the last 33 years, longer. One of the things I wanted to point out is I've shot at ranges all over the place, not just in Virginia, but Florida, Tennessee, Georgia, all over the place. Multiple ranges, and all ranges, every range I've ever been to has some level of instruction. It'd be insane to think, if you've ever been to a range, you know what I'm saying is true. It'd be insane to think that you're not going to have instructors at a range. You're not going to have safety instructors, RSOs. To think that's not going to be the case would be crazy. The idea of it being a private school, I've also been a private school administrator. I've also opened private schools in Florida and helped pods and things here, Christian schools and stuff like that getting started. And so the fact of the matter is to make a determination that Scott is running a private school, i.e. something that you could instruct in math, English, science, social studies, whatever, is kind of crazy. But the determination of using that term the way that they're using it in this thing would be to, in my humble opinion, torture the definition of what a school is in the sense of a shooting range. And so what I'd say to you all is in this particular matter, knowing that private instruction is going to happen at every single place is paramount to the subject here. You have to know that's going to happen, and you wouldn't want it any other way, in my humble opinion, at a range. I can tell you, when I first encountered Scott and his family, with my background in law enforcement and years of handling a weapon, shooting competitions, I shot at Quail Ridge when Chris owned it. He wouldn't let me come on the property with a weapon until I went through his safety brief, until I received some instruction from him. And at first that kind of blew me away a little bit, but at the same time, I respect that in the sense that the amount of safety consciousness that he has is impeccable. And I furthermore would say to you all, to not allow instruction on a range or to assume that it's not going to happen, just is crazy. So I would ask that you realize that that's the case. Thank you.
Thank you.
In this case, Stefan, can you share your screen for me with the PowerPoint that's online, or excuse me, on the SharePoint?
Y'all should be seeing it now.
I'm good.
Thank you. Of course, this pertains to the expansion of use at Quail Ridge as a private school. As far as the appeal of the zoning administrator's decision, similar to the last one that we ruled on, the May 12th, 2023 zoning determination determined that an outdoor shooting range and a private paramilitary school are separate land uses, that the grandfathered or non-conforming use at Quail Ridge as an outdoor shooting range does not include the ability to develop and operate a private school paramilitary training facility. Moving along for timing's sake, we have a definition of an outdoor shooting range and we have a definition of a private school. Both are permitted by special exception in the A2 zoning district. I won't read the definitions itself unless you'd like me to, but again, they're both defined. The shooting range is defined obviously in the land development regulations. And as Mr. Kirtner said, the private schools are not defined. But section 301 of the regulations, that's one of the very first sections, states, except otherwise provided hereon, all words shall have the ordinary and customary meaning, dictionary meaning. Per Webster's dictionary, a school is defined as an organization that provides instruction and the process of teaching or learning, especially at a school. You heard over this presentation, you'll hear specialized instruction. Mr. Kirtner said he's unaware of where specialized instruction came from, that term. I'll refer you back to his Exhibit D of the Webster's Dictionary. It just so happens that it's Section D. It's an establishment authorizing special instruction. Furthermore, Webster's Dictionary defines a private school as a school that is established, conducted, and primarily supported by a non-governmental agency. We touch on the Sheriff's Department range. I'll get to that here in a second. The May 12th, 2023 letter determined that an outdoor shooting range and a private school are separate land uses. It further determined that a school and a shooting range are separate uses and both are uses by special exception. Next slide. The Quail Ridge is a grandfathered or non-conforming use. That's important to remember, as an outdoor shooting range in the A2 zoning district. Along with the determination that states the two are separate land uses, the May 12, 2023 zoning determination determined that the grandfathered or non-conforming use as an outdoor shooting range does not extend to a school, private school, paramilitary training facilities. The regulations do not allow expansions of grandfathered or non-conforming uses. Section 708 of the regulations state that is the intent of the ordinance to recognize that the elimination of existing lots, buildings, and structures or uses that are not in conformity with the provision of this ordinance may be subject to health, safety, and general welfare as prevention of the establishment of new uses that would violate these provisions. It goes on to say it permits these nonconformities to continue, but is the intent of the ordinance not to encourage their survival, to permit their expansion, not to permit their expansion, or to permit their grounds for adding other structures, uses prohibited elsewhere in the same district. Furthermore, section 708.03-1 is more detailed. It states no such non-conforming use shall be enlarged or extended to occupy a greater land area than was occupied at the time of the ordinance. With that being said, it also states that no such non-conforming use shall be enlarged nor extended. I just wrote that, I apologize. The regulations are in accordance with the spirit of the underlying zoning ordinance and sound planning practices that restrict rather than to increase these non-conforming uses. Per the website, quailridgesportingclub.org, Quail Ridge Sporting Club offers the following classes and training in the following area. Next slide. Concealed carry training, classes in advanced weapon handling, long rifle range instruction, mission planning and employment, active shooter training, and consultation for facilities hardening, weapons training, kinetic drills for pistols, rifles, and shotgun handles, basic and advanced close quarter battle training, force on force combat training, and vehicle offense and defensive driving training. These classes and training are specialized instructions that are currently being offered at Quail Ridge. Again, as the May 12th, 2023 zoning letter determined, an outdoor shooting range and a private school are separate uses. That the grandfathered or non-conforming use at Quail Ridge does not include the ability to operate a private school. The May 12th zoning determination would not preclude Quail Ridge from providing basic firearm safety rules, requirements, or guidelines for the range. If this class is 1 hour, if it's 2 hours, that's not our purview. We applaud Mr. Guys for his safety of his range. Next slide. Since the appeal was filed, there's other changes to the website. The calendar events have been removed from the Quail Ridge website. But when they were up, they included times for pistol training, times for rifle training, times for courses such as concealed carry courses, and included other classes and training opportunity. In some cases, these activities were scheduled to commence at 5 a.m. The calendar actually distinguished the times between rifle and pistols training and then provides separate days for rifle and pistol shooting. The logical reason for this: classes, courses, and training or activities are associated with a school and are entirely separate land uses from a shooting range. Again, the ordinance the determination does not preclude safety, would not preclude safety range officers being there, but that's different than the organized, again, the establishment authorizing specialized instruction. Next slide. The next few slides are just a couple pictures from the website, old Facebook posts, those type of things. Along with the current advertisement for classes and trainings, there were numerous social media posts detailing the classes and training that were being held. The next few pictures provide examples of specialized instruction for close quarter battle training. This post says, "Come train with us at Gray Man Solutions and Quail Ridge." This post, under the same post, says, student missed me completely at this distance with 2 shots, while another one states that the instructor is, quote, evaluating the stealth of a student, in parentheses, noise. In the comments section, one reply stated that the improvements look good, brother. Quote, Quail Ridge Sporting Club responded by saying, just getting started. You just wait. You can skip this slide, please. The next few slides show some additional classes and specialized instruction that were taking place at Quail Ridge. If you can hit enter twice, please. And enter on the kinetic drill training, I believe it is. Now, again, the ordinance, I'm sorry, the termination letter does not preclude safety. It does preclude this type of specialized instruction. Next slide, please. This video shows what appears, oh, go for it. Next slide. This video appears to be vehicle driving and vehicle offensive, defensive driving training that is currently offered. Could play on both those, please. Other shooting schools, and that's exactly what they are, other shooting schools call it tactical driving and firearms training. In both these cases, you can see the car comes around the corner and they're firing from the car into the range. The May 12th, 2023 zoning determination is logical and correct. A school and a shooting range are separate uses. Both uses are used by special exception in the zoning district. Next slide. Again, and if you could hit enter twice. Again, the May 12th would not preclude landowners from providing basic firearm safety rules or guidelines for use of the shooting range. The May 12th, 2023 zoning determination does determine that the grandfathered or non-conforming use as an outdoor gun range does not include the ability to develop and operate a school paramilitary training facility. This would include, to be clear, this would include, the list is this, concealed carry permit courses, classes in advanced training, long rifle instruction, mission planning and employment, active shooter training, hardening and softening facilities classes, weapons training, kinetic drills for pistols and rifles, shotgun handling, we gave examples of basic and advanced close quarter training. It should be noted that they are not using real guns in the clubhouse. That portion of that video, what I believe, and correct me if I'm wrong, was the enclosed structure. There's actually a YouTube video that was included in it. Mr. Guy states, while pointing to the open air portion of the clubhouse, that he's going to enclose it and turn it into a classroom. He has enclosed it and he has turned it into a classroom, and he is teaching students in that said classroom. It's very clear. The purpose of this presentation is explain the basis for the determination. Next slide. The purpose of this presentation is to explain the basis for the determination that an outdoor shooting range and a private school paramilitary training facility are separate land uses, and that the grandfathered or non-conforming use at Quail Ridge as an outdoor shooting range does not include the ability to develop and operate a private school paramilitary training facility. The guys purchased a grandfather facility, an outdoor game range. They did not buy a special event venue, nor did they buy a shooting school. If they would like to develop and operating a private school paramilitary training facility and provide specialized instruction as indicated in Webster's dictionary, the May 12, 2023 letter determined that a special exception was required, and that is a path forward. In my opinion, that is the correct path forward. We currently have an application going through the July cycle of the Planning Commission and Board of Supervisors that pertains to expansion of use. It's not an uncommon reason for rezoning, nor it's an uncommon reason to apply for a special exception. We recently, probably a year ago, long time grandfathered campground was doing some expansion, exchange of uses. They came in, they worked with the county, and they got the proper approval, and that expansion is currently under construction. Per section 15.2, 2309, powers and duties of the Board of Zoning Appeals, the Code of Virginia, the decision of the decision on this appeal shall be based on the board's judgment whether the administrative officer was correct. It's important to understand that it's the determination of the administrative office shall be presumed to be correct. The appellant has the burden of proof to rebut some presumptions of correctness by preponderance of evidence. The board shall consider any applicable ordinances, laws, and regulations to making this decision. As far as the county sheriff's department facility at the landfill, unlike Quail Ridge, that is not a legal non-conforming grandfathered use. Contrary, it's operating under a special exception permit. Both the sheriff's department facility and Quail Ridge are located in the same zoning district. It's an A2 zoning district. Here's the kicker. Per section 603.02-10, public service buildings are permitted use in the A2 zoning district. What is a public service building? It's to include government facilities necessary for public health, safety, and welfare. Additionally, if the sheriff's department would like to develop a clay course at their property, they would be required to come in and amend the special exception permit. To compare a government facility owned and operated under a permitted use for a training facility and a use by special exception to compare a government-owned facility operating under a use by special exception permit, to a training facility that is a non-conforming grandfathered use is totally, it's a total fallacy. With that, as the zoning administrator for Rockbridge County, I'm confident that this decision is logical and correct, and hope that based on the evidence presented here tonight, that the members of the BZA will uphold the May 12, 2023 zoning determination pertaining to the ability to develop a private school. And briefly, per Mr. Salb's certificate of level 1 shooting instructor, verifying him as a beginner or novice instructor, this was discussed at the May 19th, 2018 BZA hearing. At the time, Mr. Salb detailed what services were offered at Quail Ridge. With that being said, he did not take this opportunity to detail any classes or specialized provided at Quail Ridge. Furthermore, the staff knowledge that there's never been any advertisements or social media posts, and we have a lot of them pertaining to the old ownership, that show any specialized instruction at Quail Ridge. Furthermore, other than a certificate identifying Mr. Salb, the previous owner, as a beginning to novice instructor, there was no evidence provided here tonight to identify such use existed. With that, I appreciate your time.
Thank you, Chris. Board, do you have any questions?
I apologize. At this time, I'd like to turn the floor over to Mr. Christopher Dadak.
Appreciate your time. Chris Dadak on behalf of Mr. Sladen. Mr. Kerner's presentation touched upon res judicata, and I think it was brought up in every appeal filed. So I want to briefly touch on that. As he mentioned, the notion is if you've litigated something before, you can't relitigate it again. But staying here today, I understand the argument a little better. Written appeal just said it was decided before, you can't relitigate it. Well, looking at the materials presented today, the argument's a little different from what I understand is, well, you had an opportunity to litigate it before, but you didn't. Now I want to briefly explain why that's incorrect. So the prior case was also a termination letter from Mr. Sam Krickenberger, went to the BZA, was affirmed by the BZA, appealed to the circuit court. When appealed to the circuit court, the only thing the circuit court can look at is the zoning determination letter. You can't add claims, you can't subtract claims, you can't add any more to the court's jurisdiction. There was one determination letter from that time from Mr. Sam Krickenberger, and that's regarding rifle and pistol shooting. That's the only subject matter before the BZA, and the only thing the circuit court could have looked at. If you look at all the case law provided by Mr. Kerner, none of it's land use. There's a good reason for it, because that's not how land use works. There's no legal principle obligating a zoning administrator to find every possible zoning issue at that time. And furthermore, if you want to be really technical about it, every day that Mr. Geis is having a use on there that's outside the bounds of his law of non-conforming use, that's a separate violation. Which is also why it doesn't apply in these situations, because every time he does it is a separate violation that could be brought to someone's attention and can be litigated. Now, nothing today is relitigating that prior case. None of Mr. Slayton's determination letters are based on the type of shooting involved, rifle or pistol shooting. So res judicata does not apply. If you have the time, feel free to look at their case law, but I've looked at it, none of his land use. Because it does not apply in these situations. And even if it could apply, it wouldn't preclude these zone determination letters because every separate event is another reason to file the sender letter. There's no obligation for zoning administrator. It's impossible for zoning administrator to find every possible zoning issue, submit a letter. I would also submit there's no evidence, Mr. Slayton indicated, there's no evidence that all of this presented today was occurring at the time of that determination letter back in 2018. So I just want to touch upon res judicata, and I appreciate your time. Thank you.
Thank you. Board, any questions?
I think it'd be appropriate to have your rebuttal as ordered in the.
So a lot of issues have been raised in addition to what I specifically addressed in my initial comments. So this is going to be a little more wide ranging. I had hoped to compartmentalize the res judicata analysis and argument and focus it more on the expansion of use, but I don't think I'm going to be able to do that. Now, can I get my presentation back up?
Start or
That's where we start. So, and can we, speaking to council, we've agreed that everything I put in writing and put in the notebook is going to be in the record of all three appeals. So I don't have to repeat this wonderful argument on res judicata, which I'm sure is going to be compelling and riveting and make everybody want to stay here another hour. So I don't have to repeat that in the next appeal. Can we agree here on the record among council that everything that I'm going to say now about res judicata, I don't have to repeat in the next appeal? I see nodding head. We're all in agreement on that, right?
That's
Right.
fine.
It'll all be in the record of all three appeals. Everything.
You don't need to reach each case word by word.
Right. Okay, great. So that'll save us a little bit of time. So the first thing that I want to do though is Mr. Geis, could you come back up here? Let's see. So I want to ask you first about this list here that's in the zoning determination letter. Active shooter training sustainment, consultation for hardening, facility hardening, faculty cadre sustainment, weapons training, kinetic drills. You see this list, they have it. I'm not going to read the whole list, okay? Do all of those activities involve shooting activities?
Absolutely.
Every single one?
Yep. And just to be clear, since no one asked me, that's me driving the vehicle, and students don't drive vehicles. It's shooting out of vehicles in and around your passenger so you don't shoot your passenger. Private security details. Secondly, I mean, you listed shotgun handling. That's interesting considering that's, a pretty good portion of what we do there. But the facility hardening. So I'm also an anti-terrorism force protection officer, Marine Expeditionary Unit qualified, meaning I go overseas to instruct people on how to harden their facilities. That includes their ability to shoot and defend themselves from there. And how does that apply to everybody else? Schools and homes. Okay, obviously we don't have firm bases here. That's where that comes from.
Okay. So, and do some of these shooting activities that are listed here that we've been discussing, do customers or the patrons engage in those because they also participate in sports related to those shooting activities?
Yeah, there's quite a few, and I'm pretty sure I touched on this before. Especially 3-gun and stuff like that. You'll see many props, as we call them, of vehicles out there and whatnot, where they have to shoot in and around vehicles. And that's a competition. That's not, we'll say military training, if you will. But I mean, in order to get to those, standards of safety, you have to conduct this training at some point. You can't just hand somebody a gun and have them do these things. They're going to shoot the vehicle, potentially sending a round back at themselves, glance one off where it shouldn't go, shoot someone else, wrong target, things of that nature. Does that answer the question? Okay.
That probably answers the question. I may have some more questions for you, man. I'll let you know. So, I'm sorry. What we haven't talked, it's been mentioned briefly, but the definition of outdoor shooting range: permanently located in an improved area that is designed and operated for the use of rifles, shotguns, pistols, silhouettes, sporting clay, skeet, trap, black powder, or other similar shooting sport in an outdoor environment operated as either a business or a club. Okay. And so that's the definition that the court, the Rockbridge County Circuit Court, was dealing with in 2019. And that's the slide. So here's what Judge Dreyer concluded. And he was wrestling with this definition, and certainly it was kind of a specific discussion about rifle and pistol shooting. He says, as discussed above, and I won't, the whole opinion's in your documentation if you need it. Outdoor shooting range is a single use, and the activities listed in the provisions are not separate and distinct uses, and the activities are examples of firearms, shooting sports, and targets. They are examples. They are not an exhaustive list of the shooting activities that fall within the use of an outdoor shooting range. The things that Mr. Geis has just described for you that are in this letter, they are other examples of shooting activities. They do involve instruction, but they are other examples of shooting activities. And I think I need to ask you to be precise about what we're talking about now. You've heard Mr. Sladen talk some about expansion, and I think that's a pertinent discussion on the next appeal we're going to talk about. But this appeal doesn't, this determination really doesn't say it's an expansion. It says it's a different use. School is a different use. And so what you're asked to decide is whether he's correct in saying that this is now a school, because these training activities, all related to shooting activities, other examples of shooting activities, as Judge Dreyer has determined, somehow change the use from being a school, or excuse me, from being a shooting range to a school. I understand, as it relates to the Sheriff's Department, that they're on a little bit different footing because they're public body, they're public, operating a public facility. But what's important about that zoning letter, and they got a special use permit to do a shooting range, is the very letter that provides them the special use permit says you can do training there. It says we're granting the special use permit for a shooting range to, I think, to satisfy or something of that nature, the training needs of the Sheriff's Department. So what that says is that at least when it came to the Sheriff's Department's application in 2014, the county took the view that training was a part of a shooting range, and it was okay for it to be a part of a shooting range. That's the point. Not that he should be sending a violation letter to the Sheriff's Department, but the county has demonstrated in prior situations not related to Mr. Geis that they accept the notion that a shooting range involves training. And all of this stuff that we're talking about is training. And let's not get confused about expansion. They're saying that these things are a separate use, okay? And Judge Dreyer's already said that's not true. Now, res judicata. So there is a corollary, res judicata, to get really detailed about it. Here's a slide. This comes from a U.S. Supreme Court case. And explains why we adhere to the doctrine, why it's important. It dictates there be an end to litigation. It's got to come to an end sometime. You can't just keep hauling people into court, relitigating issues at least that could have, or maybe even were litigated in a prior setting, in a prior case. And that's a Supreme Court case. Res judicata, literally interpreted, is a thing adjudicated. It's done, it's over, case closed, right? There is a separate sort of doctrine that comes from res judicata that we call collateral estoppel. And that's what some attorneys call issue preclusion. So res judicata is the whole thing has been decided. You can't relitigate it. The whole case, the whole cause of action, it's all been litigated and decided. Collateral estoppel is what we call issue preclusion because it applies to specific individual issues within a case. And so what we're really going to be talking about probably is some specific issues the judge has decided. And the one that I just showed you is one of those issues. His interpretation of the ordinance that separate activities are not separate uses, that is precluded from being relitigated because he's already decided that. And that particular finding is not specific to the zoning determination because he's interpreted the statute in that situation, or excuse me, he's interpreted the ordinance. And it does apply to all matters that existed at the time of the prior judgment of decree and which parties had the opportunity to bring before the court. Okay, so here's what's going to be important. If you look at the materials I provided to you, and I can represent to you that among the things that the court had in front of it when it reached this decision was that entire transcript from the last year. So all that stuff was in the record for the court to consider at that time. All the testimony from the prior hearing. So the court had all of that when it made that decision. And so here's some language from another case, and it says, you know, that whole doctrine is founded on two maxims. One, that you shouldn't be vexed for the same cause, and certainly Mr. Geis continues to be vexed by the county over essentially the same issues. And two, it's for the public good that there be an end to litigation. And then one more quote, you know, attorneys love these quotes from cases, and you'll have to excuse me. The Supreme Court said that this maximum, this principle that it needs to come to an end, comports with common sense as well as public policy. So it may not be fair to ask you folks who are not necessarily lawyers or judges to get too far down in the weeds on these legal doctrines and Latin phrases. But it's not unfair to ask you to exercise your common sense. And I suggest to you that what your common sense is telling you about this, in terms of the school, in terms of what we're going to talk about with the expansion, is that the county's just trying to get another bite at the apple. They have taken additional shooting activities, and they're trying to avoid what the judge has already done in terms of saying that shooting activities are not separate uses. And so they've tried to recast this whole thing to say that in this instance, it's a school. I also ask you to take into consideration, you know, when you're looking at this, I don't really know where this paramilitary thing pops up. I mean, Mr. Sladen's letter initially is talking about the definition of school. It doesn't talk about the definition of paramilitary training facility or whatever he calls it. And all of a sudden we get to the end of the letter and we're talking about a paramilitary training facility. Question is not any of that. The question is whether by simply providing instruction, which was all well and good, when the county granted a special exception to the Sheriff's Department in 2014, whether providing training and adding shooting activities changes the character of this from a shooting range to a school. And I'll suggest to you that the answer under the law and applying common sense is no, it did not. And just looking back through my notes, since this is a rebuttal, I want to make sure I've responded to the things that I need to respond to. This is not a school. You know, it's not a school. Lowe's isn't a school because it does some training, offers classes. Sheriff's Department shooting range, not a school. That's really the question. Is this a school? And understand that in this particular instance, the definition of school and that is baked into what they're telling you or telling Mr. Geis he can't do that. So this letter, maybe a little differently from the last letter, is applying that definition of school to say that the things that you're doing there constitute a school, and then saying you can't do those things. So it has a real world impact on Mr. Geis. So we would ask that you conclude that the use of some instruction and training, even the use of a classroom, that those things do not transform shooting activities conducted on a lawfully grandfathered, non-conforming shooting range into a school.
Thank you. Okay, I've got a question. Has to do with the website. Actually, the name of the website. What is the name of the URL? Quail. .org.
Yes.
So I have to ask myself, what does .org mean? Now, most people use .orgs are nonprofits or charities or non-government organizations or open sources and even educational platforms. So I have to ask myself, what is an educational platform? Is it a school? Is it training? But the .org kind of sinks it in that you're not a .com. So I guess I'm curious why you chose .org as part of Quail Ridge's URL.
Sure. First, schools are EDU. That's the
Some
first
schools
thing.
are.
Secondly, I didn't choose that one. That's the second iteration of us because we had .com before. I mean, they even have it on their stuff. The reason we're not .com now is because I didn't like the provider we were with. They tried to basically pull one over on us, about $600 worth. So in order to preserve that, that domain, I had to pay another $600 on top of that. I was like, forget that. We're going with GoDaddy and we'll just change it to .org.
Okay.
So that's why that happened. I don't sit around and think about those things to make these kinds of decisions.
Sure. That's all the questions I have. BZA, do you have any other questions?
I have a few questions. I understand that instruction and safety and proper handling of firearms is integral to having a shooting range or club. I understand that a lot of these classes or instructions that you offer fit really nicely in with the shooting sports that you provide.
Yes.
There was a long list of classes and instruction that you provide, and I'm curious if you could correlate those classes with different shooting sports. I ask that because the definition of a shooting club and range includes rifle, shotguns, pistols, silhouette, sporting clays, skeet, trap, black powder, and similar shooting sports. And I'm not familiar with all the shooting sports out there, but I'd like to learn a little bit about some of those relative to the classes and instructions that you provide.
Sure. Before I cover that, it's also important to note, the state statute regarding and how they address shooting ranges. It's not shooting ranges, it's outdoor sports shooting ranges. Okay, and that's a very important thing because that would be every shooting range that you have. It's, again, and I guess you can disagree, of course, we're doing this play on words thing, but let me grab my.
Sure.
So you don't have to read. Okay, here we go. All right, so active shooter training and sustainment. There are plenty of hostage scenarios in 3-gun and steel challenge shooting, as well as rifle situations. Our 22 long rifle matches specifically do that as well, where you have a hostage, terrorist type, situation, and they're under time and they're trying to figure out, which is which, that kind of thing. Let's see here. Let me try to keep my finger on here.
So active shooter training and sustainment.
Yes. Consultation of facility hardening. Okay. Again, like I said before, this is not, I'm not over there teaching people how to lay block or anything like that. I'm talking about their positions. Well, quite literally, all of those shooting sports that I talked about before center and around finding a shooting position on the prop and their various props. As a matter of fact, if you saw that stuff that was out there when you guys were out, those are various props. And of course, shooters learn very fast that, what they think is going to work doesn't work, from the position they have, their own physical limitations, to the heat of the actual prop, if it's hot outside or what have you. Let's see here. Facility cadre sustainment, weapons training. Okay, so again, people come to me for weapons training, and a lot of those same people are, the last attorney I had for the BZA hearing was an actual competitive pistol shooter. And of course, in order for him to do that, the tournaments aren't going every day, so you've got to go to a range and you've got to get that sustainment training. Let's see here. Force on force combat training. Yeah, that's an actual sport with simunitions. It's expensive, very expensive. Simunitions on average are about $2 a round.
Simunitions are
8 bullets. It's the same thing we use in the military.
So
and you can shoot at each other.
There is a sport for that.
Yes. You also, well, as a matter of fact, you also have cowboy fast draw. Okay. And that one, okay, never mind then. The vehicle offensive and defensive driving training. I think I talked about that before. Again, we're not letting anybody drive. Okay, that would be ludicrous. Secondly, the ability to shoot in and around vehicles is again, props that are actually out there. I mean, I've got a prop, for instance, with the 22 range. That's the back of a pickup truck that we bring out from time to time. And you'd be surprised how many people cannot figure out how to do that, the right way and under the time, time constraints that they have. Let's see.
Is there a shooting sport that involves shooting from a moving vehicle?
From a moving vehicle?
As you teach with the offensive and defensive.
I wouldn't say it's like an actual sport, but what you saw was not a shooting out of a moving vehicle. That vehicle came to a complete stop. I'm not looking to get killed. Long range rifles, specialized instruction. Yeah, I mean, quite literally long range tournaments, precision rifle series, NRL or National Rifle League. Sorry. I mean, there's a myriad of, long range tournaments, and very popular, very, in some cases expensive, $10,000, $20,000 guns. And I'm not exaggerating. I think that's it for the list. Am I correct?
I think so.
Okay.
Thank you.
Yes, sir.
Yeah.
I had a question for you, Mr. Guy. Sorry, make you stand back up. I just thought good timing.
Need the exercise.
Do you shoot machine guns at the gun range?
No.
Okay.
I don't have a class 3 license.
Okay.
Now, that being said, with my training and people understanding trigger reset and whatnot, because I know that claim has been made. And I don't even own a machine gun. Like if you were to watch me shoot, yeah, I'm fast.
Mhm.
And, these guys that compete, they're very fast. I mean, they have to be. Everything's under time. So, and then when you have multiple people there, I mean, that's multiple fast shots. So, no, but to answer your question, no, we're not firing machine guns. Again, you would have to have a class 3 license. Now, if a person wanted to come out and do something like that, I don't suggest it. It's not something I want to deal with. Matter of fact, I don't even allow steel penetrating rounds in my range or gremlin rounds. And all of this is stuff that I brief people before they ever even come out over the phone.
Mhm.
It's, the problem we have here, okay, is that you have a lot of folks that think that they know what's going on in the range. And for 2 years, I attempted in a PR stand, if you will, to try to make them come up and figure this out, and talk about it. Those things didn't happen. Now it's being used against me. So if I sound a little defensive, that's probably where it's coming from, because I did try. But then when I did try, and then the one time it did happen, that is further being used against me. I know it sounds like, oh, the world's against me and all that kind of stuff. I'm kind of at the point now that, it doesn't really matter. I mean, we've got, the word has to get out there, and, eventually this is probably going to go to court. I don't know, but that's the direction that the county seems to want to go. I mean, outright, making me guilty in the public eye of something that, I'm still innocent of, in your own words. So that being
I'm
said,
just curious. I've seen a lot of shooting ranges where that's like a big draw to it.
sure, mostly out in
Somebody wants,
Texas
because
and
you can't shoot a
Arizona.
machine gun. You can buy citizen can buy a gun, but you have to have a specific
Well,
license.
well,
So
what
I
I'm
know that's
saying is I'm not required to have that license for somebody to shoot it on my range. I just don't allow it on my range.
uh-huh.
I don't want the responsibility. I don't know the person. Am I qualified? Of course, but there's no reason to have it. I
Okay.
mean, there's plenty of other places.
Yeah. Just want to know. Just curious.
I guess while you're still there,
Yes, sir.
a quick question, just kind of like in defending from your idea of it not being a school and more of a training facility. Can you kind of just give an estimate of like how many people are you going to have that you'll be teaching? You know what I'm
If you
saying?
want, maybe student to instructor ratio, that kind of
Yes.
thing. Okay, so I limit myself to no more than 10 people at a time. Obviously I'm capable of more than that, but okay, let me back up. No more than 10 people at a time when it comes to rifle and pistol. Okay. When it comes to sporting clays, folks, it's not quote a limitation. For instance, and I guess we'll get into the other issue of the 5 stand that, is clearly not expansion. But regardless of that, there's 5 people that can stand up there. It doubles for me both as a weapons evaluation platform for those folks so that they can shoot one at a time. I can go to this person, watch them shoot, make sure they do everything they're supposed to do, can operate the weapon safely, load it safely, so forth and so on. Then I move to the next one, kind of like an assembly line. Then they move out, and then the next group moves in. Matter of fact, the chairman saw that last time with about 65 people. So I don't go out of what I think I can control, and really 10 is my limit because it's just not. I mean, I've been instructing in an operator for 30 years. I mean, this is what I know, and your pride and ego doesn't factor into any of this stuff because that's how people get hurt. So,
Right.
Did that answer your question?
Yeah, and that's kind of what I was trying to get at it for kind of discuss it for the group, like the determination that you're having all these training courses. But to me, most of that part of the world, I've ever been in, it's kind of a lot of one-on-one interaction,
Absolutely.
maybe with a group of people, but it's
Sure.
not like it's not like you're doing a large classroom type setting. And obviously when we were there, this facility is not built to.
No, I can tell
bunch
you
of
honestly,
people.
sir, that there's not been a single person that's ever come to, we'll just say pistol, for instance, ever shot with me, well, rifle too, that I have not had to correct in some form or fashion for their own safety. And it's usually before they pull that first shot. If they've never shot a gun before, I'm gloved up. My hand is over their hands to make sure it doesn't come back and hit them, and then I can grab the gun, especially if it's hot. If it's a rifle, most people that come out, their scopes are canted wrong. They didn't mount it correctly. Whoever they hired to do it didn't do it correctly. I mean, these are all the things that I would bore you to death, but it's been my life's work, if you will.
Yeah.
So no, I'm not going to push those limits. And again, I live on the property. you know, my house is no more than 100 yards away from these ranges. So I'm definitely not going to endanger my family, if that makes sense.
Yes.
Another question.
Yes, sir.
Are most of your classes and instruction kind of a one-time thing, or is it a reoccurring, we'll come back next Wednesday and, or a week long?
So I've got
How-
very few folks that come back that do like a scheduled thing. One of them being my chiropractor. And then, but most people, what it is they, and you know, I don't know if this means anything, you know, and no disrespect to the county. And I want to say this very clearly. I don't get a lot of business from the county because people already own land. They don't need to come to a shooting range to shoot. And I don't begrudge them of that, and it makes sense. My clientele are mostly from out of town, 2 to 3 hours away, or passing through. Like this Sunday, I've got a lady that, you know, her husband never shot a gun before. She's from Georgia, you know, and she wants him to shoot a pistol because for whatever reason. But he'll get a full safety briefing. He'll get full instruction on how to operate that handgun before that happens, you know, and part of that includes the ability to conduct speed and tactical reloads because they want it for home defense. Well, it doesn't do you any good if you don't know how to operate the gun completely. If I were to demonstrate that, which I'm not armed, if I were to demonstrate that here in this room, it would probably amaze some of you that are not familiar with it. Okay. 1.5 seconds, maybe. That's what I've been doing my whole career. And I can make a person do that in about 2 seconds, or be able to accomplish those things in 2 seconds, be comfortable with their firearm. And as we tell them, part of our motto is to make you more safe and competent, even if I never see you again. So, you know, alumni people that come in for their reunions with BMI, yeah, they're passing through. It's, is it every 5 years or something like that, you know? So does that answer your question, or?
It does.
Okay.
One more question.
All you want.
Sounds like most of the instruction is to satisfy a person's need or curiosity at the moment. Are you providing a certificate or something like that at the end of a series of?
The only certificate that I provide that means anything would be your concealed carry certificate. But unlike other schools or classes, if you will, like Safe Side Tactical, and I'm not running them down. Okay, there is no federal, state, or whatever standard other than the age and what the state has now passed that you have to attend a physical course. Okay, no more online courses, thank goodness. And that's not just from a business standpoint. The point being is, you can go to some places like there, walk in, sign your certificate that's laying on the table with your name on it because you've already signed up ahead of time, and watch whatever 2 hours of PowerPoint, that kind of thing, and then pay your $35, I guess, and you walk out. And if you would like to come back, you've never fired a shot, by the way. If you would like to come back later for, you know, their advanced training or whatever, I think they call it concealed carry 2 or something, then you start doing some shooting. I don't know what that all entails. For my piece, I'm not comfortable signing my name as an NRA instructor and everything else in my entire career on someone's certificate to hand to the county clerk's office for this state to approve, that has not gone through not only my class, but also my qualification course. You're shooting at least 300 rounds, depending on your physical ability. Got a lot of older people that come right now because they're scared, you know, and I get that. So yes, I am signing a certificate that I am lawfully able to do, that they can take to the county clerk's office and apply for their concealed carry permit. That's the only one that I do.
Okay, thank you.
Okay, can we, if there's no more questions by the board, can we open this up for public comment? No more than 30 or 3 minutes. Thank you. Is anybody on the list, Chris?
Yes, sir. First up is Mr. Hunter McCoy.
I just want to say at this time that these first two appeals that Mr. Geis is making basically have already been covered by the court case that happened several years ago. So to me, it's all mute what y'all are doing. You know, you're wasting taxpayers' dollars again. Thank you.
Next up is James Maxwell. Jamie, excuse me.
First, I'd like to say, just the grandfather non-conforming use is what this is about. Everything that Mr. Geis has described and others about a shooting range and shooting sports would be great if you start at the beginning of the process, meeting with the Board of Supervisors, find a safe location and do those things there. That would be great. But this is a grandfather non-conforming use, which is really just a gentleman's club for a number of years. With respect to myself, a little bit more, 3 years active duty in the military, 5 years National Guard, 10 years as a hunter education instructor. I've been shooting firearms of all sorts since 1980. Third, Mr. Kirkland, I think, or Kirker, Kirkner, thank you, said in his, at one point, I reject the notion that there's going on out there with respect to paramilitary use, and he also talked about that in his rebuttal. I'm submitting these in evidence. These are from Mr. Geis's website. They deal with the Institute for the Defense of Rockbridge County, which he created and called a militia. And that was in 2020. And that went from March through. There's a training regiment here. It says, 1, welcome to new IDRC members, debrief and recap. Train the trainer, continue to combine field skills, and wrap up. They did this monthly. And so who should receive this? Where does I have to look at that? I also went and observed 2 of those training events from Mrs. Hu's side and saw over 20 individuals with various paramilitary gear. Right at 20, they had helmets, they had plate carriers, and they were engaging targets with sidearms, being a pistol on one or other hip, thigh, and they also had various AR-15 style firearms. And they would engage all those targets, which were metal targets, in the area that is the pistol, and then they went down the rifle range and shot from various barrels across into the woods, which was his woods, and my farm was on the other side of that. From Mrs. Hu's side, I counted over 100 rounds, bullets and rifles rounds, impacting the trees and going through the canopy. With respect to safety, what Mr. Geis has said, that's simply not true. I hired a retired law enforcement officer to come out as a private investigator and witness shooting events at the shotgun range. And I have multiple papers that show shot coming onto my land and on Mrs. Hu's land. I advised Mr. Geis about that when he first bought the place, and he's done nothing about that. Finally, we called the Virginia State Police. Special investigator came out, saw the same thing. He was charged with reckless handling of a firearm as accessory before the fact, and the evidence was found sufficient. And Mr. Geis is the person who was charged with that. The shooters could also have been charged with that. It is not safe. It's not safe. That's public record.
Miss Jamie, I've got a question, given your background and also given Mr. Geis's background. So based on your statement, do you feel like the range meets AR 385-63? Which is the Army and the Marine Corps adopted safety manual that you both probably had to study and learn inside and out while you were both enlisted.
I'm not familiar with that. That's not my area of specialty.
Okay, I apologize.
I do know that Steve Hart, an engineer, submitted his form, correctional report concerning the range after looking at the footprint, the size, who had built ranges for years in the Army, and as a professional engineer with that experience, determined that it could be made safe, and there's a lot to that. You really need to go look at the document. But that as it was, it wasn't. And the only reason I bring that up is because in the first issue and the second issue, there's been a lot of discussion and talk about safety. The fact is that bullets, and I mean bullets, so pistol and rifle, were shooting through or ricocheting off targets and going into Mrs. Hu's land, and that shotgun pellets had in the previous 5 years come onto our land, being our farm, and Mrs. Hu's, and even with knowledge, we finally took action, and that's why the Virginia Police got involved. Those are the facts. Thank you.
Thank you.
Next up, we have Chevy Volpe. Sebi, I'll get that right next time. I apologize, sir.
So Mr. Maxwell has brought up a case that is under advisement from a judge, and he has instructed the state police to come back out to the property and reinvestigate it from Mr. Geist's side of the property. I'll have the board know, since he brought that up, we weren't going to bring it up until he did, that an internal investigation was done by an investigator, and a determination has been made and made very clear that shot did leave the property on the said date that they're referring to, but it also has been made clear it did not leave from any one of the stations when the Sporting Clays course was being used. So what was determined by the internal investigation was there was an unauthorized shooter on the property at the time in which the state police officer was put into position. And it has also been determined by that internal investigation that the only way that that shot could have reached that officer in the time that it did was the shooter had to be much closer than any one of the stations. It also was determined by that internal investigation that the only people on the property, by the court documents and by the record, that knew where the special investigator was Mr. Maxwell and Mr. Slayton, who happened to be on the property that day. So if we're going to talk about that case in here and make that relevant to whether Mr. Geist is able to, appeal this or not, the facts need to be determined, and it still is out under advisement from the judge. And I think it's inappropriate for it to be brought up here.
I agree with you, sir. This is about, determination on if this is being used as a training facility and not as a range. So I apologize that I let the meeting move out of that, and I didn't help by asking about that Army regulation. So my apologies.
Next up is Scott Miller.
Good evening. My name is Scott Miller, and I'm from the Natural Bridge District. My statement tonight is to add context to this whole situation. It's going to add some clarity, and I'm going to summarize it with some controversy. Okay. Number one, I am not a neighbor of Quail Ridge, and I don't shoot, trap, and ski. So I don't have any skin in that game in any capacity. I started following this case in 2018. And by the way, everything that I say tonight, I have brought documents to support. I started following this case in 2018 or so with a little bit of curiosity, primarily through the newspaper. I began to follow it more closely as it went before the Virginia Supreme Court, and Quail Ridge won. Not once, but twice. The state Supreme Court basically told the zoning board to stop wasting their time and taxpayers' money. But this situation got very interesting last month. In March of this year, Geist was charged with a misdemeanor gun violation, and the trial was held on June 16th of this year. The three people who have been primarily involved in this, and this is contextual, okay, is we have Ms. Hust, Mr. Maxwell, and Mr. Geist, okay? These are the transcripts. The highlighted parts on these transcripts are from Ms. Hughes' testimony in Commonwealth v. Geist from literally just a month ago. The first part, she says that she claims that she's only there approximately 50 to 70 days a year. That's highlighted. Okay, those are her words, not mine. In the second part of the cross-examination, she asks whether or not she ever allows hunting on her property. She answered no. However, upon cross-examination, literally less than 30 seconds later, she was asked, is there a family named Deacon that hunts on your property? Her response was, they have permission, yes. So we have a landowner who's absent 75% of the time. 90 days would be 1/4. So 75% of the year, she's not even there. It's rather curious. Another person that's involved, and this is a newspaper article, just a little snippet from the Rockbridge Advocate. It's dated January 2011, and I would like to read it. Assistant Rockbridge Commonwealth's attorney Jamie Maxwell tendered his resignation after more than 6 years on the job. He declined to say if he jumped or was pushed. The resignation,
That was 3 minutes.
what's that?
That was 3 minutes.
Yes, sir. The public has a 3-minute opportunity.
Can I get an extension? Would you allow that? Would the board allow that? I will skip the rest of the context. I'm sorry.
I'm not sure how relevant this is to what's on about using it as a classroom.
I
I'm
understand.
failing to follow that. I'm sorry.
I understand, and
I'm trying to stay on target. That's
sorry.
all. I'm trying to stay with the issue at hand. I apologize. But it doesn't seem like this has anything to do with the class conducting classes and his use of the range.
With your permission, sir, would you allow me to bring in a part that is relevant primarily to the zoning board and the administration? I can skip the context and go directly to.
Oh, yes, sir. Go ahead. You've got the floor.
Okay. Okay. The interesting part, and this is the controversial part as well, is that on October 21st, there was a shooting event, a trap and skeet event held at Quail Ridge. This was October 21st of last year. According to court testimony, both offered by Special Agent Spencer of the Virginia State Police Department and Mr. Maxwell, Mr. Sladen was hiding on Miss Hughes' property, waiting for them to come over there in order to facilitate a criminal investigation. Okay? I have this in court record. So this is not hyperbolic. This is not rhetoric. This has been entered into the court record, and I will conclude with this. My first question is in what capacity was Mr. Sladen present? Since when does he have the authority to sneak around the woods, placing the residents of this county under surveillance? Both Maxwell and Special Agent Spencer testified that Sladen was leading them through the woods on the Hughes property. Is this how our tax money is being spent? One of the things that we've asked tonight is why does Mr. Sladen and Mr. Geis not have any communication? Maybe it's because part of Mr. Sladen's job responsibility seems to be voyeurism. And so I am asking respectfully, Mr. Sladen be terminated for conduct unbecoming of a government official. The Fourth Amendment states that we have the right to feel secure in our property and our possessions. I will be presenting this statement in full, along with all supporting documents, to the Board of Supervisors next month. I give you my word on that.
Thank you, sir. Is there anybody else, Chris, on the list?
That was all that was signed up. At this time, I'll ask Stefan to recognize anyone online.
I do not. Oh, Miss Hughes has just raised her hand, so I'm gonna go ahead and allow her to speak. If you just unmute yourself, Miss Hughes.
Are you there?
Yeah, we can hear you.
First, I would like to say that Chris Sladen was on my property because I invited him to be there, because he needed to see what was going on. Secondly, I do not recall answering in court that no hunting was allowed. I said that I allowed hunting. They asked if it was the deacons, and I said yes. As I said earlier, our community became accustomed to a glorified hobby, almost exclusively sporting plays, 2.5 days a week, with a handful of organized shoots per year. That was prior to 2017. Then the only instruction that took place at Quail Ridge was limited coaching for patrons with very little or no experience shooting clays, and perhaps a tutorial for folks who purchased a firearm from the previous owner. There was so very little activity other than shotguns that our community didn't even know it was going on. You've already gotten a laundry list of what the current owner is offering as far as instruction. The current owner, without the required permitting, expanded what was little more than a 300-foot path with a pile of rocks at the end that was referred to as a rifle range to a 1,500 to 1,600-foot range, the length of which is within inches of my property line. There are no berms or other measures to ensure that shots and or ricochets do not cross the property line. They do. It's a dangerous situation. Will it take someone on my land being shot for this to stop? If folks teaching children reading, writing, and arithmetic in A2 zoning using paper, pencils, and technology are required to obtain special exception permits, it makes no sense that someone teaching anything to do with firearms is not held to the same standard. Firearms can be deadly. Paper, pencil, and technology usually not. The current owner has enclosed an area for a classroom, again without permits. Classrooms are found in schools. That's what he called it, a classroom. He's had militia training resulting in countless rounds zooming through my trees as well as becoming embedded in my trees. He has a history of doing as he pleases, not caring if it's permitted or safe. This has to stop. I've heard a lot about the safety that he teaches. He does not teach anything about safety of rounds going on adjoining property. I can guarantee you he will not have his range safety officers or anybody else at his facility lining up along the property line while shooting's going on, because they will be shot. Thank you.
Thank you, ma'am.
Stefan, I'll ask if anyone else has their hands raised.
That was the only hand raised. I don't currently see any additional hands.
Okay, any other comments from the board?
Is this our discussion time before we make motions?
It might be appropriate to close the
Yeah,
public
okay,
hearing
yeah.
if that's.
Yes, I apologize, Chris. You're right. At this point, I'd like to close any public comment. Now, yeah, we're able to talk amongst the board.
So a question I have is this: there's a tension between what Mr. Sladen showed us of the intention of a grandfathered use, non-conforming grandfathered use, and it not becoming bigger. I thought of the analogy, and analogies all fail in lots of ways, but like if you had a general store, like how there's, used to be lots of those, right? Lots of country stores around. Well, it doesn't mean you could just put a gas station and then it becomes Walmart or something. That use of a store grows, right?
That's getting to our next issue.
Yeah.
Or is this about the?
Well, so that's what I'm thinking is, I feel like the conversation got into a lot of that. And not just that, but what I'm thinking in terms of looking at these two motions is that they don't have to do with with some of what we've been talking about thus far, which is not bad. That's okay, because it has to do with the next thing we're going to talk about. But so the biggest tension then for me is the instruction and safety piece versus it being officially a school. Like my kids go to a private school here, and I think you asked a few questions that, there's a curriculum, there's a start date, there's an end date, there's, lots of stuff that you have with any school, right? So I don't know if we have enough information right now about whether this is or is not a school in my what I've heard so far.
Yes, and in my opinion, from what I've seen, I would not consider it a school. I would consider it training.
Sounds like
Because then I think training is very useful. A lot of it is one-on-one. That's kind of, if you understand how those things work, I mean, you have small groups of people and you want them to be trained. There's a lot of people with, just who buy a gun but never learn how to use it. So there is a purpose for that. So from the school perspective, I don't think that's an issue. And then from like the idea of like the comment with the paramilitary side to it, there's a lot of tactical training that I know people who do those kind of shooting competitions, and they're expensive, but there's a lot of different styles of competitive shooting out there that unless you really know, you don't know that exists. And a lot of those take a lot of individual training that for the most part, I don't think would be in the office. And the kind of the way I see it is like, we don't have it here, but like when you go like for a canoe float trip or something, you're going to have a meeting, and like before they throw you out with your life or with their equipment, they're going to teach you what to do safely before you start. So that's where I see the difference, but I'm just kind of want to get anybody else's opinion.
Or if you're into various shooting sports and you want to improve your ability in them, you're going to take some training ongoing, I would think. I don't think that would necessarily constitute a school if you went occasionally to improve your skills in shooting sports.
And then with the two pieces to this portion of the meeting, so one is that the specialized instruction activities occurring on the property meet the definition of a school private, and that a shooting range outdoor and a school private are separate uses.
So you have to take it all or nothing.
It's all or nothing. That's what I was wondering. Okay. The second part, that a shooting range and a school are separate uses. Yeah, it's the only place I'm getting slightly hung up, I guess.
Yeah, that's kind of where I'm getting at. I just don't see it. Now, I think it's an issue that could come up later if it becomes a larger, and and I guess that would be kind of from the county. If it does become more than just that, are they out of compliance with their special exemption permit if they were to actually put in a
They
school?
are not under a special exception permit. They're grandfathered. And that's the real key to this appeal.
So what happened? How does it deal with it if we say it? If we're disagreeing with the opinion that it's a school, and then it becomes a larger type facility.
I think we'll get into that.
At that point, he would have to apply for a conditional use or special exception permit.
To clarify your comment, Mr. Pufall, at what point are you referring to?
Well, if Mr. Geis would like to use this as a facility to conduct classroom instruction, qualify students to shoot, that type of, should we call it structured?
Specialized instruction.
Correct. Then if I'm understanding the question, at that point, currently, our zoning administrator believes that he should have that special exception permit to use it. Currently, he does not, but this does not preclude him from applying for a special exception permit to instruct further quote unquote classes. Is that correct?
Could you repeat it? I'm not following your line.
No, I guess I'm not sure if what I was hearing was correct, but if Mr. Geis were to apply for a special exception permit to conduct classes, should he take this to the next level? I think is that what I heard? I'm not sure if I heard a question or not.
So, as far as as far as what you've heard from my testimony, what we have said is an outdoor shooting range and a private school paramilitary training facility are separate land uses. Both are uses by special exception in the agricultural zone. It was stated, before I go further, number 2 was the grandfathered and non-conforming use at Quail Ridge as an outdoor shooting range does not include the ability to develop and operate a private school. And so to further along those lines, what was said earlier was that you can't do this. It just blanketed, you can't do this. Well, that's not correct. That's not what the determination said. The determination said that you are required a special exception permit if you want to start a private school, which again, a private school per definition that's included in D of the exhibits is specialized instruction.
Thank you.
And I think
Real quick, the determination of administrator officer shall be presumed correct, and the applicant has the burden of proof to rebut such presumption of correctness by preponderance of evidence. So I'm not sure your question, Mr. Pufall, if there's a threshold. The threshold has been set, and what what I have determined was that threshold, again, does not include a range safety officer, which would be common at a range. It would not include an 2-hour long briefing on safety prior to sending a shooter out there. But it does preclude the specialized training, which is the very definition of a school, to go on at Quail Ridge without a special exception permit.
And I feel like I need to respond to that. And I'm going to resist the urge to re-argue everything. Okay. It sounds to me like you gentlemen were on a path to a decision and kind of we're trying to figure out how to sort of document that path. And I need to commend your attorney on what she's provided to you, because she's provided you, I think, with a pretty good menu of options and how you follow what you're thinking about it to a path to a decision. And I would commend that form to you. It seems like you're already looking at it, but I would just simply say that before you get into any of the other findings, it's just a threshold question of whether you think the determination was correct or not. And I will also say that I think that question really hinges on whether you think it's a school or not. That's the issue. And if you think it's not a school, then the zoning administrator's determination was not correct. And of course, that's not advice to you. That's advocacy. But you start there. And if you make any other findings, that's fine. But if it's not a school, his decision was not correct. And I would not take the bait to believe that somehow that decision doesn't preclude, his determination doesn't preclude Mr. Geis from doing things, because it puts a list of things he cannot do under that zoning determination.
So the way I think of this is, if I had a driving school and I'm a driving instructor, is that and because I may not have a classroom, because a lot of the lessons are taught behind the wheel. Well, so I have to ask myself, if I'm going to compare this with something, is a driving school? Is it considered a school? I mean, it's the definition of a word. Scott, Mr. Geis, how do you charge your classroom participants for the services of you giving instruction?
By the hour, or if it's a concealed carry class, because I'm not going to charge them $40 an hour, because
Sure.
It's going to go as long as I feel that I need to go, where I'm comfortable to sign that certificate. I'm not going to put my name on somebody that they could potentially hurt someone. So I will tell you this, that like most of the training I do, for a group or individual, I don't usually go over 2 hours because mentally people just get drained, and that's when you can start having safety issues, and that's my personal standard.
Check.
That answer the question?
Yes, sir.
Okay.
I think similarly, probably a driving instructor would do the same thing. He would drive with that student until he felt comfortable that he or she would be able to pass an examination of some type. So,
For the record, I would determine a driving school would be a school.
okay.
So the zoning determination is that safety briefings around safety, et cetera, are accessory to being a gun range, but providing specific instruction on specific topics as the definition of a school broadly is makes it a gun range school.
I think there's a little bit of a, maybe not gray area, but something in between that you could go to shoot some sporting clays and want to improve your game and get some coaching or lessons as you're shooting. And that's different than the basic safety instruction. I think a lot of the classes that were described fit into improving a shooter's ability in their chosen shooting sport.
Yeah. And there's nothing wrong with that. I'm thinking as a business, though, that's another arm to your business if you're now providing instruction for hire, so to speak.
I went to Quail Ridge 20 something, maybe 25 years ago, when I got first shotgun and learned how to shoot sporting clays with Chris.
Mm-hmm.
So I was familiar then that more than just the basic safety, but some instruction on how to do the sport well. Yeah.
Any other discussion? Does the board feel that they're in a position to make a motion?
I'll move that the decision of the zoning administrator be reversed. In support of this motion, make the following findings. The decision of the zoning administrator is not correct, and that the activities on the property do not constitute a private school, and that the activities are not separate uses.
I'll second.
All in favor?
Aye.
Opposed? Aye. It's a split decision.
What was the final vote, sir?
2 and 2, 2 ayes and 2 nays.
The motion fails, correct?
Correct.
Forgive my ignorance. What do we do when the motion fails?
We move on to the next one. If no one has any objections to moving on to the next one.
Can we take a 5-minute break between
Certainly.
then and now?
Yes, sir.
All right, we'll adjourn for a 5-minute break.
There's next one. What?
Yes, where you are.
He is there. Specific. Where we go.
That means it stands.
Yeah.
Yeah, well, when he said you weren't, he said I think what he said is it's a special use. It's a special use, grandfather non-conforming use. But
Okay. Everybody have enough time?
I was told to mute the main boardroom, so once everyone's back in there, Chris
Thanks.
should unmute it.
All right. Chris, you ready to start the meeting?
Chris, you'll have to unmute the main microphone. Chris, y'all are still muted. You have to go over to that PC to unmute. I can't unmute it from here. Chris, please, you got to unmute the microphone at the host PC in the corner.
Thank you.
Sorry, Stefan. How about that?
We hear you loud and clear now. Thank you.
Perfect. Sorry about that. I'm not sure how that got muted.
I'm not either.
I was asked to mute it during the break since there were people discussing matters during the break and it was being recorded.
Okay. I'd like to go ahead and re-adjourn this meeting. Next topic, Scott G. Geis and Crystal Geis, 336 Merritt Road, Lexington, Virginia, 24450. Application to appeal the May 12th, 2023 zoning administration determination that the grandfathered or non-conforming use at Quail Ridge Sporting Club has impermissibly increased and requires a special exception permit to operate at the current scale. Mr. Sladen?
Yes, sir. Notice is hereby given per section 15.2-2309 and 15.2-2204 of the Code of Virginia and section 808 of the County of Rockbridge Land Development Regulations that a public hearing will be held by the Rockbridge County Board of Zoning Appeals on Wednesday, July 19th, 2021 at or around 7 in the Board of Supervisors meeting room in the County Administration Building, 150 South Main Street, Lexington, Virginia, 24450 to consider the following application. Scott G. and Crystal Geis, 336 Murrah Road, Lexington, Virginia, 24450 has made an application to appeal the decision of the zoning administrator on May 12th, 2023. The zoning administrator determined that the current scale, current use scale at Quail Ridge Sporting Clubs has impermissibly increased and requires a special exception permit to operate the current scale. This decision is under appeal. The property is identified as tax map number 73-A-17 and it consists of 84.21 acres per tax records and is located on the east side of Murrah Road, Route 675, approximately 0.76 miles north of the intersection of Murrah Road and Collierstown Road. Collierstown Road is further identified as Route 251. The property is located in the Cards Creek Magisterial District.
Thank you.
Mr. Sladen, can you help me get my, yeah, no, that's fine. I appreciate your help. All right. So I'm going to try not to duplicate things that we've already talked about, but some of that may be unavoidable. So it doesn't seem to want to move forward. It's past its bedtime too.
That's why I sort of emphasize at or around instead of after being stated. Current slide.
Okay, here we go. Again, trying not to duplicate. So I've talked to you about one of the findings that the circuit court made in the decision in 2019. And again, that opinion from Judge Dreyer is behind tab, let's see, behind tab E. And you'll see the final order that was entered, and you'll see the opinion that was issued by Judge Dreyer. And so one of those findings was, as we've already discussed, that different shooting activities were not separate uses. All shooting activities were allowed under shooting range. Here's the important finding that I want to talk to you about now. He also concluded, found that the guises have not changed the character of the grandfathered use. And I'm going to suggest to you that that's the real critical question when it comes to the alleged expansion or the increase in use that the county makes a centerpiece of this third determination letter that we're talking about. There's a case that's in your, that's attached or as an exhibit 3, baton tab 3, called Knowlton versus Browning Ferris Industries of Virginia, Inc. And that is sort of what we would call the seminal case in Virginia on how we determine if a grandfathered non-conforming use has increased or expanded to a point that it's no longer allowable under the grandfathered use. And the standard there, and this is, I think we probably all could agree on this, all the lawyers in the room at least, is the question is whether the character of the use has been changed. And this court case, if you look on page 5 of it, it says that a grandfathered use doesn't have to remain static. In fact, you know, traditionally courts took the view that just increasing volume, intensity, or frequency of the use, and this is on page 5 as well, didn't change the character. The Knowlton case, you know, didn't give us a bright line, unfortunately, as to when an increase in frequency or usage becomes a change in the character of the use. But you don't really need to worry about where that line is, because Judge Dreyer worried about where that line was in 2019. And he made this finding that on the record that existed then, the Geises had not changed the character of the grandfathered use. And without going blow by blow on as to everything that was before him then, I mean, I think you can look at the determination letter that was issued by Mr. Sladen and see that but you can see that most of these things that he's talking about and he relies on are things that were developed in the record back in 2017, 2018, and 2019. So they were all things that were available and in the record that Judge Dreyer was looking at in 2019 when he said the Geises have not changed the character of the grandfathered use. And just as an example of some of those things that were already in the record, Go back here. Let's look at this. So one of the things that was submitted in the last proceeding was, it was by an attorney who represented the landowners. I believe his name was Mr. Bauer. And he was trying to make the point that there had been all these increases in uses or activities on the guy's property. And so he did this little table, and this little table was put into the record. Now, I don't necessarily agree that all of this stuff is accurate. However, it does stand for the proposition that there was a lot of information, complaints, information provided to the county back at that time about increases in use since the time that Mr. Geis had bought the property. So all that was before the judge. Then, let's see.
What page is that on in the packet you gave us here?
It is, it's not numbered. It is in the slideshow, which is kind of right in the front.
Okay.
And I don't think our slides are numbered. I apologize for that.
That's all right. Thanks. I'll find
But
it.
so it's there, and all this was in the record at the time. And again, a lot of what you see in the zoning determination letter is references to stuff that was going on back in 2017, 2018, and 19, which Judge Dreyer had in front of him when he said the character of the grandfathered use had not been changed. And, you know, the county was aware of these things, and they didn't care yet. So I'm putting another slide up here for you. And this is an excerpt from a deposition that was taken. Mr. Geis's prior attorney, Mr. Haley, took the deposition of Mr. Krickenberger, who was kind of I guess he was the zoning administrator at that time. And so he's asked about increased activity, which is apparently what we're here talking about today when we're talking about this expansion, the increased activity. There's more shooting, there are more customers, there's, you know, some additional structures supposedly, which we'll address. And so Mr. Haley asked him, well, what were the nature of the complaints you were getting? And he said, well, you know, the increased activity on the property, both relating to sporting clay operation and particularly rifle and pistol shoot. So it's already an issue of increased activities there, shooting activities. And the county was trying to make the case that those increased activities really were beyond the bounds of the non-conforming or grandfathered non-conforming use. So he explains what the complaints were. And then Mr. Haley asked him directly, well, does the increased frequency make any difference to you? Different activity makes a difference to us, leaning into the county's argument that they were making that each of these activities is a different use. Then he asked him even more specifically, well, that wasn't my question. Does increased frequency of the sporting clays activity make any difference to you? And here he's speaking on behalf of the county, and he says it did not. So in 2019, the county knew that there were increases in all of these various activities that they're complaining about right now. And they had decided they didn't want to pursue that argument at the time. Their theory of the case was, well, every activity is a new use. Very easily could have said, and those additional activities are increases in the use, increases in the frequency. Didn't pursue it. And so that's the record that Judge Dreyer had in front of him. Now, all of a sudden, after they lose on that issue, and, you know, I've pointed out to you that Judge Dreyer ruled in favor of the Geises. It was appealed to the circuit or to the Supreme Court of Virginia. There was a petition for appeal that was denied. They moved for rehearing, reconsideration. That was denied as well. Now, this is really getting you down into the weeds of appellate advocacy. Appellate procedure. So when you're aggrieved by a decision of a trial court, the circuit court in this case, and you petition for appeal, you have to tell the Supreme Court what your grounds for appeal are. You have to say to the Supreme Court, here are the things the judge did, said, concluded, found that we're objecting to because we think those things are wrong. Well, behind tab F, you will see that we've got an excerpt from the petition for appeal that was filed by the county. And I just took portions of it, but you look on page 1, that's what we call the assignments of error. That's, here's what the judge did wrong. Here's what we're objecting to about what he did. And you won't see that there was an objection to that finding by the trial court. So the finding that on the record that existed then, which included much of the stuff that this zoning determination letter now includes, the finding by the trial court that had not changed the character of the non-conforming use was unchallenged by the county. And it may be more accurate to call that what we call issue preclusion, collateral estoppel. But on that point, as of that time, snapshot in time, that issue was decided. And that is the issue when we start talking about the expansion of the non-conforming use. It is a question of whether it changed the character of the use. And the court decided that as of October 2019, and then later when the appeal was denied by the Supreme Court, that the character of the non-conforming use had not changed. Now, I'm going to yield to Mr. Geis to address some factual things, and we may have another witness that we want to present as well.
Thought I was going to just bring up that chart that I saw. Really no point because literally 99% of it's inaccurate. And people will take my word for it or they won't. What I will tell you is that when I'm reading this, this violation letter here, besides, making me guilty in the public eye before I even had a trial, thank you for that. And if you're not aware, he literally states in the violation letter that shots from at least 2 stations are falling on adjacent properties. I want to make sure that we understand that every one of these letters is full of just fluff of grievances. This is a hate and spite issue. I'm curious, before I get any further, are Board of Supervisors members allowed to be in here, considering that if I went in circuit court and you guys have to appeal, would they recuse themselves?
Board members are allowed to be here as members of the public. They're not participating in the proceedings.
No, but they're hearing testimony that they wouldn't normally hear, right?
All of this is public record. They have access to
Okay,
it.
just making sure we got that on record. Thank you. So, right here, it says Quail Ridge Sporting Club, Clays, was a sporting clays facility including limited rifle and pistol use. You already went against everything you already argued about. With weekend use and 4 to 6 annually advertised organized shoots throughout the year. You have no paperwork on that whatsoever that limits me to that at all. Not to mention there were league shoots that were happening bi-weekly, tournaments happening monthly. So, moving on. This is transition to what now Quail Ridge Sporting Club, a sporting clays and 5 stand, which by the way was in existence of the BZA, which you stood on my property and said this is expansion and was ruled against, which advertised the ability to host special events and weddings and a paramilitary training facility, shooting school, numerous activities, blah, 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 because you continue to just regurgitate the same stuff. You go further in here talking about, and you really need to educate yourself on the game of 5 stand, by the way, when it comes to sporting clays, about how many people could shoot there. And just to put this in perspective for those of you that saw the 5 stand, okay, 5 people don't shoot at the exact same time. That'd be ludicrous, okay? It's a position for 5 people to be prepared to shoot. They have a menu to shoot, and regardless of whether you had 1 person there, 80 people, whatever, all the shots in the clays are in the same area. Argument we made before, but certain people don't want to hear it. That being said, you also have in here, you talk about the building. You say I had no zoning approval and a building permit. I don't need zoning approval, first of all. Second of all, I talked to the building department, which is amazing how once this all came out, I can't get a hold of them. Because Jason came out and we had this specific discussion because he came out to talk to me about putting on a porch for my clubhouse. And I asked him, do I need to freaking get a building permit for this? He said, no. Kenny said the building's been there forever. You don't need one. But you probably didn't have that conversation with him. Secondly, I noticed on there, on that chart, it said 200 watt and went to 400 watt. You have to have permits for all of that stuff. All of that was approved. But you choose to use it against me as if it's some crime that I've committed. Also, you made note, basically, I mean, it's amazing, I mean, you literally could have came over, with the right attitude this time and looked at what you thought you perceived in Facebook. They're literal partitions. Thankfully, the BZA members saw that. They're not walls, meaning they're not attached to the floor or the wall or the ceiling or anything else. They're attached to each other by 2 screws each. Operating hours. Chris Saab, the previous owner, owned 4 businesses here in Rockbridge County. Okay. Paving, car wash over by Walmart, boarding kennels, and the shooting range. His hours, okay, are not my hours. His pursuit in life is not my pursuit in life. And again, there is no documentation anywhere that precludes me from my hours or how I want to conduct that business in the time frame. To include, I say again, state law and your own regulations that say businesses, industrial, special use, agriculture, all of these, because that was the initial complaint, was noise. All of that has to do with it. But you want to sit here and literally the entire argument here from the county is, well, you weren't wearing a red shirt with a pocket on your left breast back then. And now you are. That trash can wasn't there when Chris Saab was here. That's the argument that we're at here. And if this is falling on deaf ears, I'm not saying it is, but if it is, I can't do anything about that. 6 advertised shooting matches and organized shoots per year. Please show me any documentation that says that I'm beholden to this. You don't have it. By appointment only. What does that mean? What that means is when I feel like dealing with a shooter out there or a group of shooters. So if that shooter only has the availability to shoot at 9 in the morning on a Sunday or whenever it is, if I feel like I want to get out of bed and accommodate them, then I will do that. Again, you have nothing that precludes me from doing that otherwise. But you state all this as if I've broken some law. I noticed that you guys also removed the verbiage of the 30% expansion pending administrative review because the judge told you couldn't do that, but you didn't tell anybody that. Just like you didn't tell anybody that you denied that you guys were denied your appeals. We have 49 traps, not 32. Okay. And something else that Mr. Sladen makes specifically for the 5 stand is that you've got all these traps there. You know what? You're right. You got all these traps. There's 6 traps on that station alone. Do they shoot 6 clays at the same time? I don't know a shotgun that can. That's the first thing. It's a different presentation. They're put in place to literally fly based on the menu of where the shooter is shooting. What does that mean for everybody listening? That means that where that shooter is shooting, the fields of fire for that shooter are set up, or the clays for that shooter are set up based on their field of fire, as in safety, if that makes sense. And then once everybody's done with their little menu, they rotate. So again, if 5 shooters were there and they shot their entire menu, all right, how's that any different than if I had 10 people that came there and shot at one position? It's not. Or 5 people, rather. They're still shooting clays in the same area. They're still shooting off of the same traps. But that's not what all of these say. What they want, and this, by the way, I'll go ahead and say it now because there's really no reason not to. I have the documents for those of you in the audience that you didn't want to show me, that you're trying to hide an email because one of your witnesses right here put it in my mailbox. Anyway, where I'm going with this is you don't get to sit here and say that we want to put the range back to the way it was when you bought it. And that's what this is all about. Manual traps. When you talk about, oh, the automatic traps don't require trappers. Why? Because it's a safety issue for me. I don't want a trapper getting hurt. And if you've ever seen a manual trap throw, it's a giant blade that comes around. I guess you have seen it. And if you don't operate it correctly, you can get in some serious trouble. All right. By putting an automatic trap out there, I don't have that liability anymore. If that makes sense. So you want what was already there and the amount of money that we spent to put it in place to go back to this way, because the whole goal here is to make the property economically unviable for me to sustain myself. So I'll give up and leave so some people can have my property and things like that.
Mr. Guys, can I ask you a really specific question
Absolutely.
about the 5 stand and the construction of that? Is it on a foundation?
Nope. It's not even, there's no concrete or anything. That's the other thing. It's not even a pole barn. Look, I mean, I get it. You know, I mean, you don't even need a pole barn to have, I mean, a permit to have a pole barn. That was also part of the conversation that Jason and I had. If I wanted to close in my pole barn, do I need a permit for that? If you put a concrete floor in, you do. So if I want to put pieces of fencing section up to block the wind, is that okay? Yes, that's okay. That's not closing it in.
And what you're doing there is just another variation of the shooting activity of clay shooting.
Yes, and going back in history, just so that we're clear, because again, this was tried to be brought up as expansion. When I showed up, Mr. Saab, and it's not that he did anything wrong. At the time, and it probably still is in some cases, an industry standard, if you've ever shot sporting clays, where they'll use either 2x4s with lattice as a station or PVC pipe. But it's a movable station to change the presentation of the targets. They don't have to move the traps. I didn't want that liability. I wanted a fixed post in the ground. The shooter can't shoot anywhere but where I want to shoot them. And then we will move the traps, you know, if need be, to change the targets when we feel like it. Again, we're minimizing the risk and maximizing the safety by taking the shooter out of that equation. If that makes sense. Mr. Saab, most of his stations were that 2x4 thing. I didn't like it. In my opinion, there's just too much to deal with, too much, you know, I mean, we want to talk about, you know, responsibility in a range. What if I didn't see a shooter pick the thing up and move it closer, whatever. Again, those things don't happen on my range. Everything's permanently in the ground. Again, not cement. Well, I say permanently. It's not cemented in the ground. You can pull it out. That's where we're at. Everything here. I mean, yeah. I mean, if we were able to have mature conversations, we probably wouldn't be here tonight. But that's not possible with this particular zoning administration. So that's all I got. Other than questions.
We got one more witness we've called.
If you don't mind, I'm gonna stop sharing.
Okay. All right, so and let me just, before we kind of finish our presentation, just sum up a couple of things. I wanted Mr. So let's just look at these specific things that they are saying are an impermissible expansion. And again, I will tell you that in our view, the standard here is whether it changes the character of the use. That's why Judge Dreyer made that finding. It was an important finding to make. So that's the standard. So even setting aside what Judge Dreyer did, and let's just assume that you're not willing to go down the path of saying, hey, we embrace collateral estoppel or res judicata on this issue. So we still are left with the question of whether any of these things that they're complaining about change the character of the use. And what's the use? It's a shooting range. It allows shooting activities. How far do you have to go to change the character of use? Well, in that case I was telling you about, the Knowlton Ferris case, the court kind of described what had gone on there. It was a little complicated. There was there had been a kind of a small little trucking operation, a shade tree trucking operation. And the court said that the existing use when it was grandfathered was 4 small trucks parked on unimproved land, repaired and maintained in the shade of a tree. That was the grandfathered use. What they were looking at though was a company that employed a fleet of 18 large trash compactors whose repair and maintenance require a spacious garage erected on the site and 2 gasoline trucks installed underground. That, the Supreme Court said, that changed the character of the use. I would love to give you a bright line, but I can't. That's all we have to go from. That's all you have to go from. That's all the court has to go from. That's what we have as the law. And so there's not a bright line, but I would just ask you to consider that comparison from the Knowlton Ferris case to what we're comparing now. So first of all, that the instruction, I mean, we've beat that horse to death, I think. I'm not going to get you back into that. But it's our view that instruction goes with the range. Okay. So that's not changing the character of it. I mean, even, you know, those who, well, it's not changing the character of the use. The next thing we get to is the 6 shooting matches organized per year. I will say, if you look at the record, I think there was already some evidence in the record in 2019 that, you know, there was more going on at that time. That gets back to the res judicata argument. I won't drag you back into that. Now we're talking about, they're complaining, I don't even really see how many, maybe monthly they're arguing as compared with 6. I mean, does that change the character of the use? We go from 6 shooting matches to 12 or 20 for that matter. Does that change the character of the use? I would say that it does not change the character of the use. It's still shooting activities. It's not going from 4 trucks under a shade tree to 18 great big trash compactors in garages with underground storage tanks. It's not the same thing, and that's the standard. The 5-stand was already in existence back in 2019. But again, that's back to the whole the whole res judicata argument. But does providing another avenue for enjoying the sport of clay shooting, which clearly has been going on there for many, many, many years, Mullen shot there himself, does adding a 5-stand, which is not on a permanent foundation, could be picked up and moved. If you had the right kind of forklift, you could pick the thing up and move it. Is that changing the character of the use? Well, it's not. It's just another permutation of a shooting activity that's allowed with the grandfathered use. And then an increase in the hours of operation. Again, I wish I could give you a bright line, but I can't. But does increasing the hours of operation of this change the character of the use? Well, it's not a change in the character of the use. It's still shooting activities that are going on there. You know, I guess what we're really ultimately talking about is maybe the shooting from Monday to Thursday. Apparently, the evidence that the county relies on had the shooting range open on Fridays and Saturdays. Fridays, Saturdays, and Sundays before. Now it's open Monday through Friday or Monday through Sunday. Does adding 4 days change the character of the use? I'd suggest to you that it doesn't, and that's the standard. So is our view that these alleged increases in activity, first of all, they're prohibited from arguing about that because the judge has already decided that it didn't change the character of use. And even if you get past that, then even you're exercising your own judgment based upon the cases that we have to apply to it, or case law we have to apply to it. None of these things change the character of the use from an outdoor shooting range. And if it doesn't change the character of the use, then whatever increase may be involved is not a violation of or outside of the grandfathered non-conforming use.
All right, just a few opening statements there. Per Judge Dyer's quote that the Guises have not changed the character of the grandfathered use since that was obviously issued as shown on the screen in October 6, 2019. The expansions and increases since that time frame are exactly what we're here to discuss. It should be noted that all pictures, videos presented this evening were posted since that opinion was written. In terms of Mr. Krickenberger's deposition, that is correct. He was my predecessor, and he is not the current zoning administrator, obviously, and did not make the determinations under appeal this evening. What is being litigated is the time, what is being litigated at that time and what is being discussed are separate issues. The zoning determination does not, that is under appeal currently, does not relitigate those issues that were under litigation at the time. Obviously, the zoning determination is not based on what type of shooting is performed consistently throughout the night. With that being said, the May 12th, 2023 zoning determination letter determined that number one, the lawful or non-conforming use does not include the ability to hold training and simulation classes or provide for specialized instruction. So I want to pause there briefly and sort of explain the difference of the last one that changed that stated affirming the decision that they were separate uses. So what that now requires, in my opinion, is that in order to expand to a private school, he is required to get a special exception permit for that said school. With that being said, what this is talking about is that particular use on the range itself. Would he have to bring the shooting range into compliance in order to have the said school? Number two, the lawful non-conforming or grandfathered use is limited to 6 advertised shootings matches per year. Number three, the lawful non-conforming or grandfathered use does not include 5 stand. And number four, the lawful non-conforming or grandfathered use does not include the ability to increase hours of operation, nor night shooting. While the previous hearings pertain to the uses that had been determined to be separate uses, the application under appeal at this hearing pertains to the overall expansion at Quail Ridge. Since acquiring of the property of February 6, 2017, the property has been changed the name of Quail Ridge Sporting Clays to Quail Ridge Sporting Club. Along with the name change, the use and uses at the facility have expanded significantly. Quail Ridge was a sporting clays facility with limited rifle pistol use and weekend use and 4 to 6 advertised organized clay shoots per year. Should be noted those were obviously, because of the limited rifle pistol, they were obviously clays only. It has been determined that the Quail Ridge Sporting Club has impermissibly expanded to include increase of hours operation from limited weekend use to open 7 days a week and most holidays, to include night and daylight shooting, to a shooting range that now offers, quote, night and low light shooting available. A private school has been determined, and the addition of 5-stand shooting game. The expansion was done without the proper zoning approvals, in some cases being disputed this evening, building department permits, and with proper land disturbance permits. Each time the guys that started a land disturbance project without the proper permits, Mr. Guys was made aware that the after the fact land disturbance permit did not constitute zoning approval. Quail Ridge is a grandfathered or non-conforming use as an outdoor gun range, outdoor shooting range in the A2 zoning district. The appeal under consideration pertains to the overall expansion at Quail Ridge. The regulations do not favor nor allow expansions of a grandfathered non-conforming use. I'm going to skip over for timing's sake. I'm going to skip over the previous points. They were provided for at the last presentation. Again, one thing is expansion, to increase use to include training. And this would be on the gun range. At the last hearing of the Board of Zoning Appeals, the Board of Zoning Appeals upheld the zoning administrator's decision that a shooting range, outdoor, and a school, private, are two separate uses. Unlike the other zoning determination letters previously appealed tonight, this letter that's under current appeal pertains to the unlawful expansion of use. The May 12th, 2023 letter determined that the non-conforming grandfathered use does not include the ability to provide, for timing's sake, I won't read what it entails. The second one is increase of number of use to a special, increase of use number of events. The second determination was made that the May 12th, 23 letter was that the lawful non-conforming or grandfathered use is limited to 6 advertised shooting matches, organized shoots per year. This determination recognized that Quail Ridge is grandfathered to hold advertising shooting matches and shoots. This would be shooting matches, organized shoots for competitions, fundraisers, and charities. However, the non-conforming or grandfathered number of these events cannot be expanded upon the bounds of the grandfathered limit of 6 annually. Based on the information available, previous social media posts, numerous newspaper advertisement, the lawful non-conforming or grandfathered use is limited to the average of 6 advertised shooting matches annually. These events have a large impact on the surrounding area. In most cases, there's more cars, more people, and potentially more shooting. When it comes to holding advertised events, it has expanded from holding an average of 6 advertised shooting matches, organized shoots annually, to in some cases 2 matches a month associated with the rifle and pistol range portion. This is in addition to the advertised shooting matches associated with the clay court. Again, it's worth noting that prior to the name change, all the previous shooting matches and organized shoots were associated with the clay course. As discussed in the November 12th, 2019 court order, these uses listed within the definition of an outdoor shooting range constitute a single use and is grandfathered or non-conforming use. The May 12th, 2023 zoning determination that's currently under appeal did not state that the advertising shooting matches or organized shoots were limited to the clay course. And that, in my opinion, that would have been an incorrect determination. However, the court did not provide for increased intensity of scale or the grandfathered or non-conforming use. Furthermore, neither the regulations nor the Code of Virginia allow for grandfathered use or non-conforming shooting range to be increased to offer classes and training provided for specialized instruction. To the contrary, Section 708.03-1 of the regulations, that would be the County of Rockbridge Land Development Regulations, states that the non-conforming use, again, as an outdoor shooting range, shall not be increased or enlarged. As far as the 5-man stand, the third determination that was made at the May 12th, 2023 letter was the unlawful, non-conforming, or grandfathered use does not include 5-stand. The picture in the slideshow shows 5-stand. Near the beginning of the March 7th, 2017 YouTube video, Mr. Geis proceeds to target number 1. According to the YouTube video, target number 1 was a clay station that including a following pair. A following pair consists of 2 sporting clays, one after another. Since that time, station number 1 has been replaced with 5-stand. 5-stand is a type of shotgun sport shooting. With 5-stand, 1 shooter, and as noted, it also can be up to a squad, it's called, I believe, of 5 shooters, shoots from 5 stations. The station, as indicated in the picture, are side by side, and the shooters are presented with 5 clays at each stations. The addition of 5-stand not only increased the size of the structure, but also increased the number of shots from 2 to 3. One station, again, was a following pair consisting of 2 sporting plays, one after another, to a minimum of 25 shots. According to Orvis.com, 5 stand is a more exciting than trap and throws a wider variety of patterns than skeet. It's faster and cheaper than sporting plays. The expansion of the use and the additional structure was undertaken without proper zoning approvals and was constructed without a building permit. If the guys would have contacted the Office of Community Development to inquire about the addition of 5 stand or apply for a building permit, staff would have stated that we do not have the authority to allow for this expansion of use, and would have stated, or at least continued the conversation, the need for a special exception permit. In fact, again, we have one application going through this current cycle of July for the PC pertaining to expansion of use. It's not uncommon for a special exception to pertain, the spearhead for a special exception permit or rezoning even is a change of use or increase of use. As far as the hours operation crow, the 4th and final determination that was made on May 12th, 2023 letter was that the lawful, non-conforming, or grandfathered use does not include the increased hours of operation nor night shoots. On the left side shows the previous grandfathered hours of operation, Friday and Saturday from 9 a.m. to 6 p.m. and Sunday from 12 p.m. to 6 p.m. open by appointment only. Since acquiring the property, the hours of operation have increased to the current hours of, quote, open 7 days a week and most holidays, in parentheses, by appointment only, end quote. The website states that the shooting is available from 9 a.m. to sunset, typically, again, in parentheses, night or low light shooting available. Night shooting was discussed at the BZA meeting. The night shooting was discussed at the 2018 BZA meeting. Quail Ridge is a non-conforming or grandfathered use, and Section 608 deals with these particular issues. Increasing the hours of operation from a Friday, Saturday from 9 to 6, Sunday from 12 to 6 by appointment only, to 7 days a week and most holidays by appointment only, and to add night and low light shooting is an immense expansion and has a large impact to the surrounding landowners. The purpose of this presentation was explaining the basis for the determination pertaining to the expansion of Quail Ridge. If the guys purchase a grandfather facility and outdoor gun range, if they would like to expand the uses at Quail Ridge, the May 12th, 2023 zoning determination determined that a special exception is required. Again, as the zoning administrator for Rockbridge County, I feel that this decision is logical and correct, and hope, based on the evidence presented tonight, that the members of the BZA will uphold the determination letter pertaining to the overall expansion of Quail Ridge non-conforming use. Thank you. With that, I'd like to turn the floor over to Mr. Christopher Dadak for some additional comments.
Just briefly, I don't mean to rehash too much the same arguments, but I do want to address res judicata since it was brought up again. The circuit court originally had the jurisdiction to review the BZA decision on a letter regarding rifle and pistol shooting. That's what it's limited to. And that reference did not change the character of the use, purely in relation to just it being rifle and pistol shooting. As you are well aware, records will sometimes include irrelevant information. Just because there's information regarding other issues before the court, before the BZA, does not mean the court made a decision on that basis or had any jurisdiction to make that decision. It did not. It was simply limited to rifle and pistol shooting. And I just want to briefly also talk about, there's a lot of discussion about not being able to do things. This is a lawful non-conforming use. If he's outside of a lawful non-conforming use, he can apply for a special use permit. It doesn't mean he can't do anything forever, that he's completely barred from doing these things. But it does mean that he's supposed to file for a special use permit. The board of supervisors will review it. Neighbors get to come out, give their opinion on what adverse effects they see, how it impacts them. The board of supervisors sets conditions on how to limit the adverse impact of that use. Lawful non-conforming uses are disfavored for this very reason. Because anyone else who wants to have a shooting range doesn't get to just change the hours of operation, set up, and do what they wish. They have to go through a process. And lawful non-conforming use just says the law has changed. Well, you get to do what you're doing, but you don't get to change that because it's unfair. Other people have to go through this process. You don't. So in terms of any issue of fairness, as to whether he's not able to do some of these things, it's not unfair. Just go through the same process as everyone else. And if you go through an SUP process, the board of supervisors can impose limitations on hours of operation. That's not unusual in the SUP. And you don't get into this issue of, well, it's 3 days before, 7 days now. That's a big change to go from 3 days to 7 days a week, nighttime shooting involved. So I just really want to step back as to what a lawful non-conforming use is and what its options are. The zone determination said you either need to stop what you're doing because it's outside what you've been doing before, or you just file for an SUP application. He can do that. He has that process. This doesn't bar him forever from doing any of these listed things. It just means he has to file an application just like anyone else would for that use. The board of supervisors looks, what are the adverse impacts? Hears from the public how those adverse impacts affect them. You get to make setting conditions to mitigate those adverse impacts. Appreciate your time. I know it's been a long night.
Briefly because of the hour, all the talking we've already done. So implicit in what you've heard from Mr. Slayton, certainly, maybe even to some extent from Mr. Dadick, is that the use or the frequency of use in a legal grandfathered non-conforming use just can't change at all. That you take a snapshot in time, exactly what was going on, whatever date you want to choose, and it can't change, or snapshot in time as of the time that zoning came into effect, I guess I should say. Or in this case, a particular provision of the ordinance came into effect, but that's not the law. So again, this Knowlton case, I'm sorry to keep hammering on, but it's really all we've got. And it says, and this is on page 5, where you'll see the star pagination of page 237, indicating where it is in this authority, recognizing that a non-conforming use need not remain static. We consider whether the character of the non-conforming use in existence when the zoning restriction was imposed has been continued or changed. So the Supreme Court, and I will say that it doesn't matter what the ordinance says. Everybody's ordinance says it can't increase. The ordinance in this case, Knowlton, said it can't increase, just like the ordinance in this case. But this is the law that the Supreme Court has announced and that we live with. It doesn't have to remain static. So it becomes a balancing test that in that case, the Supreme Court had to engage in, and in this instance, you have to engage in as to whether any one of these individual uses, since that's the way they've chosen to kind of lay it out, I suppose, in whether any one of these individual increases in activity, whether it be increases of hours or the, for instance, the instruction has changed the character of the use. I'm having a little trouble following Mr. Sladen's argument as it relates to the instruction, because this particular zoning determination doesn't really say anything about a school, right? I mean, I guess implicit in this is the idea that it's a school, but it doesn't really say that. And so the question is whether the instruction and the use of instruction, as has been detailed in great detail, changes the character of the use. And then it's our position that none of these individually or these collectively change the character of what is going on this shooting range. And if it doesn't, then he's within his rights to continue those uses as a grandfathered non-conforming use. So we ask you to give as careful consideration to this question as you have to the other two questions that have been before you, and I'm sure you will. And in the event's my last opportunity to speak to you. Thank you for your time. Really do appreciate how carefully you guys have thought these things through. May disagree about results, but we can't really complain about the attention that you guys have given to our concerns and our appeals. Thank you for that.
Thank you. Board, do you have any questions for Mr. Sladen or the guy, Mr. Geis? So one of the questions I have then is that number 30%. Prior to the Geises owning the property, it was operated out of 2.5 days per week. Now it's 7 days a week. Simple math indicates, I believe that's more than 30%. Yes, sir.
Oh, I'm sorry. I thought you were finished with your statement. Go ahead, sir. Sorry.
So I'm not sure if it pertains to the 30% in terms of operating hours, or is it expansion of land? It's kind of out there in the ether of how do we define that 30%?
I think we're seeing the 30% because it's in that section 302 or 0.179B. And that
Yes.
applies to land usage, which I don't believe is in discussion for this case, but we're seeing that 30% about the land usage just because it's in the relevant section.
And that's what I interpreted that to. Is it beyond the existing property, or is it how the property is used? What are we using to determine this 30%?
I think we're not worried about it.
That's correct. It specifies land usage.
Okay.
And so that is not under consideration. The term 30% was utilized in this particular zoning determination letter because it's part of the definition.
I see.
And admittedly, that is a very difficult calculation to quantify with the full shot with everything else. So obviously at this time, that is not part of this appeal, I should say.
Okay. Anyone else? That was my only question regarding this.
So if we're not looking at the that 30% land use, I think then we're looking at the section 708.03-1, and that states that no such non-conforming use shall be enlarged or increased, nor extended to occupy a greater area of land than was occupied at the time of enactment or amendment of the ordinance. So I think the question is the scale of the business increased or enlarged? And that section saying it shouldn't. But then I have a question, what is the county's opinion on the court case you were referencing that did allow for or said some expansion was okay? How does that fit into the discussion?
That would be a better addressed by one of the attorneys in the room.
I mean, I can't disagree with the case Mr. Kerner has cited. You do have to look at, it's a balancing test. Has the character of the use changed? And as he said, there's no black line rule. Obviously, our position is it has changed. I would just note, obviously, just for the record to be clear, that section in terms of the expansion of land use, it would be trumped by 30% of land usage in the definition of shooting. hope that answers your question.
Not much.
Probably not.
There's not a bright line. That's the answer is there's not a bright line answer, right?
If I would try to give you a different answer, I think that'd be advice, and that wouldn't be appropriate from my position. But the advocate in me obviously says that the nature, character of the use has changed.
It does seem that we agree that's the standard, though. Would that be fair to say?
I think that's fair to say. Yeah.
So from our standpoint, we're looking at it from the county administration's office opinion that Quail Ridge has changed from its original, from its original
From its use at the time
original
of being
permitted
grandfathered.
use, and now it's out of compliance without getting.
So yes, there's 4 points. Y'all could consider, it's my opinion, y'all could consider 1, 2, 3, 4 as bulleted, and which ones do y'all feel that all of them are correct? That it changes the character of the use, as far as being able to utilize the outdoor shooting range to provide for the specialized instruction. Is the non-conforming use limited to 6 advertised shooting matches, organized shoots per year? Is the lawful non-conforming use does not include the addition of 5 stand, and fourth and final is the lawful non-conforming or grandfathered use does not include the increase of hour operations to include night shooting. That's what's under consideration.
Well, I think I get to respond to that. I mean, it's whether those things individually or collectively have changed the character of the use. That's the question, I believe.
Have changed the character, or if we're going to that section 708.03-1, has it been, the use been enlarged or increased?
So
And that's different than character.
Right. So I tried to make that point probably inartfully, probably because I'm tired. I'm sorry. So what I was telling you about the ordinance in the Knowlton Ferris case said the exact same thing that this ordinance said. Okay. And so the Supreme Court said they didn't get into it, but the Supreme Court's ruling that it didn't have to stay static and that the standard was whether it changed the character of the use was in the face of the same language in the ordinance that's in this ordinance. So that is to say that even though the ordinance may say it can't increase whatever language it uses here, the law in Virginia is that it doesn't have to remain static. And the question is not whether there's been any incremental increase at all. It is whether that increase has changed the character of the use. And I didn't make that point very well a while ago. I tried, honestly, but I just didn't get it out. But I'll make it now.
If it helps clarify, I think Mr. Kirtner did it quite well. It's how you measure the increase or change in the use, change the character. Just for example, in the case we talked about before in the circuit court, the judge actually said, well, for instance, if you had archery, that doesn't change the nature of the character of the use, right? You didn't have archery before, for example, perhaps, but you do it now, that wouldn't change the character of the use. So that's how to measure the difference of the increase or change must be sufficient in your opinion to change the character.
I think in fairness, Knowlton uses the phrase, the word quantum of the change. And again, in Knowlton, it was 4 little trucks, shade tree, mechanic sort of thing to what I described, 18 trash compactors. That clearly, we know that changed the character of use. And if that case comes up again, exactly, we'll know the answer. Otherwise, folks like you, judges, are left to balance. I'm sorry, but that's just the law.
And that may be, but if you look at Quail Ridge Sporting Club and boarding kennels versus Blue Ridge, Clay, and what the Saabs had previously offered, I mean, there's quite the expansion of operation here. Um,
Right.
and there's just no question about it. And I'm not saying that, that's not great for the business and the Geis is supporting themselves, but it does have a big impact on the neighbors. And to me, that is, that's really, how do you value that? How do you measure that? Because these people have to live, they live around the range. They realize that. The Geises realized what they bought when they purchased the property. And now we've gone from a part-time, as Scott mentioned, the Salbs had 4 other businesses operation to a full-time operation happening out in an agriculture area where there's neighbors on each side who have their own dreams and ideals. So, I can't help going with the last judge and, what we read in the Advocate, straight shots, impossible, judge doesn't buy it, because the judge himself has asked the Geises to work it out with the neighbors. So again, it goes back to how do we determine what's appropriate and what's not appropriate? And it is late and I apologize. But
I think
anyway, we should probably move to, unless the board has anything else, open it up for discussion with the public.
Yeah.
If you could formally open up the public hearing.
Okay, I'd like to open up the hearing to the public.
Thank you. First on the list is Mr. Hunter McCoy. I believe he is absent. Second on the list is Mr. Jerry Deacon.
I'm getting sleepy too. Jerry Deacon, Carter Creek District. Thank y'all for putting up with us. I hadn't heard anything about the neighbors. Mr. Geis came here. He was a foreigner, so to speak. He moved in. The Salbs came down in '92 and asked the neighbors, do y'all mind us shooting some sporting clay? We said, no, go ahead. We country people. Now it's led into this. I don't know what you would call it. But my biggest concern tonight is safety. Y'all had a picture up there a while ago of the tactical group. And they had a picture showing the shooting range that Mr. Geis put in. Not getting a permit, but he put shooting range in, so be it. But he put it right on Miss Hughes's line, right on it. I went to Liberty University I think it was 4 years ago. And they got a shooting range over brand new. They had berms 15 and 20 foot high on those berms. They were shooting down there. This is nowhere close to that. And we as neighbors have got to contend with this. And talking about your shot going into the trees, believe me, I've been there. I've hid behind trees. And I challenge y'all, the board, to go up there when they having a shoot and stand there. I tell you what, makes you jittery. So when we in there hunting, at the Deacons, when they hunting, we got to wait for no shooting before we go in there, if we go. So I just want y'all to consider the safety part of this. That picture showing the tactical, that the timber that was behind that was Martha Hughes's timber. That's how close the line is to his property. He's got 84 acres, so to speak, 82. To me, he needed more acres. His land is long and it's narrow. So he is working off that narrow section. He can't do any better. But what else is he going to come up with? And we as the neighbors, we need to say so in this thing too. It's not all about Mr. Geis. It's about our neighbors. I got grandkids right over the hill from them trees, 2 little girls, and 2 little girls on that end. And I worry about them. And safety is a factor here. I know that he's good. I know he's a great guy as far as handling the rifles and the pistols and the shotguns. But those people that he is teaching, they are new people. They got to learn the hard way. Guns got to go off before they know it sometimes. Scare them. That's what teaches them. I know it happened to me. So we got to consider the people here, not just Mr. Geis. Thank you for your time.
Thank you, Mr. Deacon.
Next up is James Maxwell.
Thank you again. 3 minutes is not very long. Context matters. With respect to Mr. Geis's attorney, when he talked about the character, whether the character of the use has changed. I have an active law license, but choose to be a full-time cattle farmer. I have a cow-calf operation on the south side of what Mr. Geis has purchased. And I can tell you the character has changed monumentally. I was there from 2010 onward at 7 years with Mr. Saab there. He conducted organized shooting events. There was 4 to 6 of them a year, 4 to 7 a year. And that was it. And I know that because I'm right there. I can see the stations. I was working there every day, building fences and continue to do so. I built my house. And those shooting events were conducted on a Saturday. And he also had to shoot on Friday, as he advertised, Friday, Saturday, and Sunday. Friday, his buddies would come out, just his buddies, and they would go out and shoot together at 9 a.m. They'd be done by 10 or 11 o'clock at the latest. And that's exactly what they did. There was no more shooting on Friday. Then there's a shooting 4 to 7 times total per year. And that's all there was. Now, and so context matters. Let me point out this chart that he referenced. Friends of Moran, Spring Valley, that's all the surrounding neighbors. We did hire Mr. Barker, an attorney, to represent us at the BZA hearing in 2018. And he tried to present the issue of the expansion, but it wasn't received. The reason why it wasn't received is because Mr. Krickenberger in 2017 issued his, or 2018 issued his notices of violation on his own accord. He did that. And once they were out there and we all became aware, we said, yeah, but what about this? What about this? And what about the bullets and the degree of use? And so Mr. Barker, our attorney, tried to present this chart, and it wasn't given any attention whatsoever. Further, we tried to join the litigation when it went before the circuit court as a group, which many are here, and there's another 40 or so outside, not here presently, but are part of it. And we were not allowed to join it, a decision made by the court, because the issue, they said, didn't concern us enough. And so this was never before the judge, as far as I know, and wasn't a part directly. But real quick, it all matters. I asked you to look at it. It's in the record. Look at it. There is night shooting going on now from 9 to 11 on 2 occasions. I listened to it. That never happened before. There is a lot of shooting out there with pistols and rifles. But to give you an idea, hours of operation before, it was truly Friday, Saturday, and Sunday. Friday morning only. Saturday, 4 to 6 shoots a year, 7 maybe. And then Sunday afternoon, maybe someone came and shot, but not before noon. Now it is all week long, to include nights when he decides. Of course, it used to be a 1/2 mile long with 6 foot wide dirt path, expanded, cut down trees, made it 8 foot wide. Mr. Saab cleaned 3 acres off in 2013 and expanded the operation. I saw that, witnessed that. Mr. Geis cleaned 75 to 90 feet wide, 1,600 feet long, and put in the rifle range. He added the pistol range and cleared that further, dug down, did that. He's just finished clearing another 2 acres in the top middle of it. I asked the group to look at what's been put in the record, know that it wasn't litigated, and that is the degree and character of use has changed dramatically, to include that my calving operation has decreased significantly from all the shooting that's going on next door.
Thank you, Jamie.
Thank you. Next is Mr. Scott Miller. I believe he left as well. And next is Mr. Volpe. Won't do that again.
I just want to say to the board, obviously this thing's going to a circuit court, no matter what happens, because the first 2 were turned the wrong way. So I just want to thank you again for your time. I want to say to the neighbors, the idea of not being a good neighbor and all of us shot leaving the property. And up until now, there's been no recorded evidence at all. And again, as I said, this latest case has put a state trooper in harm's way, and there's been an internal investigation that will come out in the wash and will come out in his newspaper, I'm sure. But what I want to say to you is think about yourself for just a minute. You come to town, you served your country for 30 years, you come to town to buy a range, you call the county, you have the county come out, they explain to you, you explain exactly what you're going to do. Every detail was explained at the time, and they still gave you a grandfather. You buy the property, you spend your money, you have a grandfather used to use this property in the sport of shooting. Because you have more clients and more people come, the neighbors now don't like the fact that they live by a range. I don't know where they got the idea that it was only used that amount of time and that was somehow part of his grandfather clause to start with. That's nonsense because it wasn't. And so the idea that he has more people there shooting does not equate expansion. It just equates more business. He was grandfathered to be a shooting range. He wants to be successful. He wants to shoot and he wants to run a safe range. They have gone to extremes to try to prove things and prove illegalities by Mr. Geist to shut this range down. That's a fact. Now, if you had spent your money, you had served your country, you'd done what you'd done, you'd come here and bought it with a grandfather clause, and you'd want to continue your business and expand, increase your number of clients, that's just good business. And so I'm sorry that the county went ahead and gave him grandfather clause when he came, but he spent his money in good faith, bought the range in good faith, and all the neighbors knew that there was a range next door when they came in because Mr. Saab had one. They all knew there was going to be shooting activities. What if Mr. Saab's business had gotten stronger? What if Mr. Saab's business had gotten better? What if Mr. Saab's business had increased? He sold it to Geist in good faith for a price, knowing he had a grandfather use. And if you all rule in the contrary to that, saying it's expanded now because he's got more people coming, this is the most ridiculous thing I've ever heard. And think about your own business. I'd challenge anybody in the room that has a business. If their business was being shut down by the neighbors because Mr. Deacon wants to run his sawmill later, or Mr. Deacon needs to run it longer and it's louder, you know, to shut him down, I believe that'd be a problem in this county. But because Mr. Geist is a foreigner, as Mr. Deacon said, and by the way, Mr. Deacon told me he was out of this. He was done with this and personally told him himself, told the preacher that. So that was a lie because he's obviously still in this. Okay. But I'm just getting to the point, and that is think about yourself when you make this last ruling. Know this, it's going to spend taxpayer money. We're going to circuit court. You're going to get beat again because the legalities of what he's raised are real, and you're going to lose. It's going to cost the taxpayers money. He's still going to get to shoot, and his business is going to be able to increase the number of frequency. There's nothing going to change about that. I'd suggest to the neighbors that they raise about $10 million and buy him out. I suggested that to Jerry D.
Thank you, sir.
I'm not done.
I apologize. I did not start the clock here when I started it.
Yeah, it was 4:30. Sorry.
Okay, I apologize. That was my bad for not starting the clock. That is all that's signed up at this time, but we'll recognize anyone else who'd like to speak. If you state your name, Matt Steele, if you come to the mic, that helps the Zoom.
And we do have one hand up, just so you know.
Thank you, Stefan.
My name is Cindy Krantz, Cars Creek District. I live on Muir Road. It's gotten kind of personal tonight. It's been a who said what. And yet, if my ears have been hearing correctly, I think we're basing our decision tonight, or I hope, on Mr. Geiss's words and on how he has advertised his business. The former Quail Ridge was a couple of days a week. Some friends getting together to shoot, occasional matches. My son was up there and Mr. Saab used to help kids earn money for baseball. It was a family run business. And that's the grandfather clause Mr. Geist bought it under. His own words. He trains people in all of this. He really gets in there. He issues certificates of completion for his course in concealed weapons. He has expanded his range. He's expanded the skeet shooting range. He's increased all the number of people who come. He has more parties up there. Common sense would tell me this needs to go back and be requested for a change. Go back through the process. You're not telling him he can't have his business. You're just telling him he has to use the process. Using his words, not ours. Thank you.
Thank you, ma'am.
That appears everyone in the room, physically in the room. Stefan, if you could allow the speaker to speak.
Okay, Ms. Hughes, yeah, there you go.
You ready for me?
Yes, ma'am.
For the record, My property has been in my family for generations. I grew up there. Whether or not I'm there 365 days a year or 50 to 70 days a year makes no difference. The fact is that I'm being denied the use of my property because of what's going on at Quail Ridge. It's not safe for me to go over there. He says stuff isn't coming over on neighboring properties. Why is it then that I pick up sporting clays off of my property? I have one that was picked up whole. By the time I got it to the house, it was in 5 different pieces. This operation has expanded to 7 days a week. Our community was used to 2.5 days a week with limited use then. When something's grandfathered, it's grandfathered to ensure that it does not change the character of the community. That an expansion, what is grandfathered, an expansion will not change the character of the community. We have more traffic on that road. One of these days there's going to be an accident, hopefully later than sooner. Mr. Guy said there's a mirror there. Well, there might be a mirror there pointing in the other direction, but there's no mirror pointing in the southeast direction. The last report that I got that somebody was almost run over, the folks didn't even give the person on the state maintained road the right of way. They came charging right on out of there. It's just plain dangerous. The increased activity at that driveway, plus shots coming over on adjoining properties. When Mr. Geis was up there with the zoning administrator, with Sam and with Chris, when he bought the property, shortly before or shortly after he bought the property, my property line was pointed out to Mr. Geis. And he said, it's okay. And it was right there. It's okay. They don't use that land, or something to that effect. That's his view on the whole thing. There were 4 of us up there one day, July 3 years ago, July 2020, putting up private property, no trespassing signs along my line. Mr. Geis came stomping out of his clubhouse. He heard us pounding posts, stomping out of his clubhouse across the clearing.
Martha, I'm sorry, but you've run over 3 minutes.
And ready to chase me off my property. Something has to change. Thank you.
Thank you, ma'am. Is there anybody else electronically waiting?
No more hands are up.
Okay, at this point, I'd like to go ahead and close the public comments. BZA, do you have any additional, anything else you want to discuss?
My understanding correctly, the previous BZA ruling that the judge issued his judgment, thank you, on, that was specifically pertaining to the pistol rifle piece of this conversation.
Right. And his judgment said that that is a,
That's not part of the character. Yeah.
So in my opinion, just as far as the hours of operation seem to be outside of what the county agreed upon. Does the county, do we have, I mean, outside of just records of that was how it was used, was there, how, are we just basing the grandfathered property use based on just basically it's changed in usage?
As far as
Previous
hours
use,
operation,
is
yes,
that-
sir.
is that kind of basically how the grandfather thing would go? Once you change that usage, then you would need special.
That's the determination that yes,
Right.
sir. One determination is that the lawful, non-conforming or grandfathered use does not include increased hours of operation nor night shooting.
We didn't ask earlier, but how often and for how long does night shooting occur?
Mr. Nice, can you address that? How often? And
Doesn't occur that often. I can tell you, I think we've done it in this year. I think a total of maybe 3 times, and it's usually about an hour. It's like as soon as the sun goes down, and then that's it. And then no, I'm not even gonna get into it. It's not worth it. You got a question?
Well, I was just curious, Mr. Geis, what, when you do conduct your night shoots, just in terms of noise, what caliber is being shot at that hour?
We've shot mostly 22. So the fact that that's why I said I didn't want to get into this, because I know you're not hearing that, but it doesn't matter what the truth is, as we already have found out. I mean, hell, the last time we had this BZA meeting, we hadn't even done night shooting, but we were accused of it, even though specifically a neighbor was doing it. And that's happened since.
I was just looking for the caliber, that's all, I'm
It's
sorry.
whatever caliber I would like to, actually. Again, now we're getting into the weeds of pigeonholing me into a corner of what I could shoot out there. Thank you.
No, that wasn't the intent, I apologize.
Mr. Geis, I had a question. So I heard you earlier, several hours ago, mention, when you were doing your due diligence on the property, I believe we're talking to, this is where, just help me clear this up. I remember you talking about, I told, was it Sam, this is what I'm going to do on the property, and you
Correct.
had a letter. Is there any written? I gave the county this. I told them I'm gonna do that.
No, I said I asked for a grandfather letter. That conversation, literally, I said, can I get it in writing that we're grandfather? And he goes, what?
Sam said what?
You did. And I was
Okay.
like, what's the problem? In my head, I'm like, what's the problem here? And I was about to look at the owner and go, this isn't what you told me. And I said, I would like to have it in writing that I'm grandfathered with the expansion to do all this. He said, well, I don't have anything right now. Can I get it to you in the future? And I took a huge risk. And I said, that's fine. You know, and we got the letter, I think, like the day before we actually closed on the property, you know, because they could have threw in whatever they wanted and I wouldn't have known it.
And that letter,
What was in the letter then?
yeah, what is that? I don't think I have that letter, so that would be,
So I didn't bring it with me, but what I can tell you is that it referenced the ordinance, okay? And then I mentioned this, I think, in the first hearing portion, that they said something to the effect of 30% expansion upon administrative review, which has been removed because that's not part of the law, and they know that. And then and the judge actually did talk about that. That's beside the point. You know, we can argue semantics all we want. And then if you look at the actual court case, the judge literally held it, because I didn't know about, you know, the sheriff's department's special use permit, had no idea. The judge is the one who pointed that out. And I think this is actually pretty important, even though you guys have already ruled on the other stuff. He looked the county attorney in the eye and he said, what can the sheriff's department shoot out there? Whatever they want, judge. Okay. And then a light bulb went off on that guy's head and he stood up again and he goes, well, we can get you something if you need it. And my attorney stood up and said, are we going to make it up as we go now, judge? And the judge kind of told him to sit down. Then he holds up the grandfather letter, holds up the sheriff's department's letter, again, that I didn't know anything about, and goes, if the sheriff's department is under ordinance, blah, 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 and can shoot whatever they want, and the Geises are under ordinance, blah, 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 show me where the distinction is. Not a word. I can't change what's going on in here, and I don't want any of you guys to think that, you know, I hold anything personal against you. But what you're hearing is not the truth. And yeah, I'm going to fight it the whole way. I didn't pick this fight, but I'm going to fight it.
so
Now that I'm a foreigner, especially.
So can you, So you're saying there's this letter, does the county have this letter?
Absolutely.
they
yes,
have it.
sir. And it was included in the supplemental information. It was included in the 2018 BZA agenda and agenda package. I
I
have,
have that in here.
yeah, absolutely. It's dated January 26, 2017. I have it in front of me if you'd like me to.
Okay.
Oh, yeah, or I could, actually, I got it.
Might just be good to reference right now. You said 2018 BZA. I'll take me a second. So if anybody else has questions.
And that was included in your fast flash drive. All the information that is
Oh, it was on the flash
available.
drive?
Yes, sir. Yes.
That's why it's.
I can't share this one.
I
can read the
yeah, that
majority
would
of
be
it.
great.
Okay, the whole letter. Dear Scott, it was a pleasure meeting.
That's fine. Yeah.
It was a pleasure meeting you yesterday. Addressed to Scott Geis, Quail Ridge Sporting Clays, the address, Shooting Club at A2. Dear Scott, it was a pleasure meeting with you yesterday. This letter serves to confirm that Quail Ridge Sporting Clays, located at the above address, further identified as tax map 73-8-17, is located in agricultural general use districts A2. Outside shooting clubs are used by special exception in the zoning district per section 603.02-19 of the regulations. As Quail Ridge was developed prior to April 29th, 2007, when this amendment was passed, it is considered grandfathered, and all current activities may continue as long as they do not cease for a period of 2 years. Provisions included in the zoning amendment allow for a 30% expansion of such grandfathered facilities pending our administrative review. See definition enclosed.
And what was the date of that letter?
That date of the letter was January 26, 2017.
Exactly. And I bought the property on February 1st, 2017.
So you got that letter,
That's when it was drafted.
and then
I got it in the mail.
that letter, and forgive me, I apparently had that letter. So, but so that letter is the letter you're saying the judge said, what's the difference between this and what the sheriff's shooting range?
They're both under the same ordinance.
That's interesting because it says grandfathered in under current uses in that letter, right?
Sheriff's shooting range is not a grandfathered one, but a special exception permit.
Yeah,
right?
That is correct.
Yeah.
And your shooting range falls under the grandfathered. but you
Well,
haven't- you
that's
haven't-
interesting you bring that up, sir, because he's even said it multiple times tonight. First, that it's under grandfathered use, but when you read the documents, it says special use. So which is it? And I've had this argument since the day, the day this all started.
I'm pretty sure it's a it's a use.
Your use is grandfathered.
It's grandfathered in. It's
I
a
agree.
special use that's grandfathered in.
But you
That's
could
the way I
apply for a special exception permit to expand or do most whatever else you want. Look at it.
You really think that's going to get approved in here?
I'm not saying it'd be approved, but
Exactly.
you could apply for it. That'd be
Yeah,
the-
it's,
the path.
again, it's nothing against you, sir. I'm glad we got the appeals process. I mean, the amount of, literal hate and spite in here is amazing.
I think it's coming from
Yeah,
us.
I don't know what
Not
you're
you. I
insinuating,
didn't,
but
not you.
okay. Well, so I don't know what you're insinuating. I'm gonna tell you, I don't think it's helping your case from my perspective as you're talking to us right now.
I
So
understand, but at this point, it doesn't really matter. Like I said, we have to
it
go to the
might.
circuit court.
So hold on, I have a question. So when I hear what that letter now says, I heard you say earlier that when you had that letter, I wrote this down. You just said this. So you said you believed you could do whatever you want on the property pertaining to shooting. And
I said
think
that.
that's just the notes I took. Whatever I want on the property pertaining. You said I can do whatever I want. Actually, just now
I
you
never
mentioned.
said that tonight.
Okay, that's all right. I'm not saying that's just the notes I took. So on what I think you said. I think what I'm hearing is that the court already determined on what he can shoot in terms of calibers and rifles and pistols. That's all
It's
done.
all, yeah, it's
Yeah,
all
so
the
that's-
definition of the outdoor shooting range.
So my thought is that anything beyond that though is we're talking about beyond what's grandfathered in.
Yes.
It would need to go
Right.
back through the public. That way the public can weigh in on these new uses.
then the confusion of the court case that may allow for some expansion.
Yeah, and that all can get worked out in the courts as there's so much evidence. Clearly, there's lots of documents here that
I mean, I fully don't even understand how the other two rulings went. So just like last time. So that's why I'm kind of like, I don't know what you guys have done at this point.
Trying to figure out the right answer based
Yeah.
on the
No, I
rules.
meant like what the decisions were, not that.
I think, if do you guys have any more questions for Mr. Guys?
Thank you.
Any other thoughts?
Do we have any motions on the floor, or would you like a continuance?
Well, that's an option. We could, not moving so, but we could make a motion to delay action. But what does that gain us? I mean, are we gonna get to the?
Can we waste or spend more time and more of
Right.
Mr. Geis's time and money on an attorney and all these things?
Right.
I think it will probably be about as confusing next time as it is this time.
Mhm. My general sense is that this is complex. It seems to go, from what I understand from this letter, beyond the initial grandfather use. And it needs to go, these other uses need to go back into a more in-depth process, whether that be through appeals or the public hearing process of getting a special exception permit for these other things. So
What I'm leaning towards is the use has expanded, business has increased, which in most cases would be a good thing.
mhm.
But that may be in contradiction to what some of these sections of the code are saying is allowed. So if we go with that, then I would say the grandfathered non-conforming outdoor shooting range has increased in its intensity and scale, and that Chris was correct in that, but I think there's more to it than that. Or maybe that's the simple answer to the question in front of us is, was the zoning administrator correct?
Mhm.
Should he have been correct or not is maybe another, or correct in that interpretation of the rule now might not be the interpretation after further litigation and discussion.
Mhm.
I don't know that we're here to decide what it means in the future, but can we go on what we think it meant in the past?
Yeah, right now.
Right now?
Yeah. Getting philosophical on us.
So when I keep getting drawn back to the criteria for permit conditions. And it states permits may be granted under suitable regulations and safeguards and must relate to the impact of the proposed use in kind and degree. Hours of operation, lighting and noise regulations, buffering, ingress, egress.
This would be if you were to apply for a special exception permit?
Yes, sir.
Okay. And when coming back to that, what do you think?
Well, based on the hours of based on the criteria for these permit conditions, I mean, everything that we've seen is the perfect storm to require that a special use permit would be required for the growth of the operation. In this case, hours of operation, types of how the operation is being used. It's grown quite a bit from when the Saabs owned it previously.
Yeah, the course I recently did for the BZA, that was the grandfather section. That was a big thing about that non-conforming grandfather uses. The intention is not to, yes, to make them more of a non-conforming use.
And I think that's kind of where we are with what has happened, and then move to make the plan with a special exemption permit, which like we just kind of went through the list of what that would require.
Okay. So do we have a motion on the table?
So just to clarify, if we reverse the motion, then thank you, the decision, then I don't know if I'm supposed to be asking you this, Vicky or Chris, but then that means Mr. Guys is no longer, this is no longer an issue for Mr. Guys, this last chunk, right? But so the zoning department cannot go back if there is another issue. Is that the case?
I believe the county has the right to appeal, just as the appellant does.
Okay.
But that would have to be a decision administratively from the board, rather than through you all. Your decision should be based on what the evidence you've heard tonight and what has been submitted before.
Yeah, forgive me. I was somewhat curious. Does the county have the right to appeal the BZA's decision? Okay, thank you.
Well, I will move that the decision of the Rockbridge County Zoning Administrator be affirmed. In support of this motion, and make the following findings. That the decision of the zoning administrator is correct. That the grandfathered or non-conforming use as an outdoor shooting range has increased in intensity and or scale beyond the limitations of the grandfathered or non-conforming use. Also, that the court order did not provide for the increase in size, intensity, or scale of the grandfathered or non-conforming use.
Do we have a second?
Second.
All in favor? Aye. Opposed? Okay. All right.
One more agenda item.
One more agenda item is the discussion on the electronic meeting policy update. Chris?
This helping with you, would you mind chatting about this? This is the same thing we did.
Have you done
The draft.
okay.
So I apologize. I was not prepared to talk about this one. It's obviously on the agenda. Ms. Huffman has provided a updated electronic meeting policy in accordance with some revisions to the law, I believe.
Let's see.
I have a copy of that. And Vicky, is there anything that's changed that between previous policy that we might want to be aware of that you want to highlight?
I'm sorry. I haven't seen this in quite a while.
Yes, and I apologize as well because the focus was not on the.
And my computer has died. I had a tracked version in there, but the changes I think were related to corresponding with state code provisions to allow a member of the, if there is a medical condition of a member of the board member's family requiring the member to provide care that prevents the member from attending the meeting, that's been added as one of the conditions to participate electronically. And
Okay.
that the personal matter, which can be used 2 times per year, each calendar year, and it's been added, or 25% of the meetings held per calendar year, rounded up to the next whole number, whichever is greater.
Okay.
I think that was it.
Okay.
But since it is changed to correspond to state code, I had prepared it for each of the bodies that had this policy to adopt the amendments.
So do we need to make a motion, or is this just notification?
This, you would need to take action on it.
Okay,
But if need be, we can bring it back next time with the changes tracked so you can see exactly what changed.
I'm good with that.
With bringing it back next time or approving? it?
Yes, yeah, with bringing it up next time, so we can just highlight the changes. So if at any point any of us need to attend remotely like I'm doing this evening, it's important for me to at least understand this.
Right, and it doesn't impact your participation electronically this evening because it's your first time this year.
Thank you. Okay, so do we need to make a motion on discussing it at the next meeting? Or
You do not, we'll just put it
Okay.
back on the agenda.
is there any other business?
No,
Okay,
sir, not on our side.
all right. Well, at this point, I would like to adjourn the meeting.
Thank you.
Thank you.
Thank you.
Thank you for all you do. Have a nice night, everybody.
Too.
Thank you.
Have a good evening. Thank you.
Not past midnight, we're here.